Good afternoon, everyone. Thank you for joining us, all 140 witnesses today. It's Tuesday, March 5th. You're in the Finance Committee, and we appreciate your attendance. We are going to hear 16 bills today. I'm going to read the bill order. These are all Senate bills: 476, 216, 234, 104, 750, 460, 1069, 871, 846. 789, 843, 844, 845, 919, 931, 431. Sponsors have as much time as they need to explain the bill. Witnesses have 2 minutes. You see the clock will come up on the board. Please respect the 2 minutes. It will show you when you're going over. That's the time to finish your sentence. So thank you very much for your attendance today. You're going to see people in and out. It isn't because we don't respect you and don't want to hear you. People are in other committees, and so they have to go to other committees to have their bills heard. But thank you very much. And we're going to start today with Senate Bill 476. And Miles Hicks is here representing the administration. This is Governor Moore's bill, and Jeff Buttle and Raquel Sesnalis. Thank you. So Miles, take as much time as you need. Thank you.
All right. Good afternoon, Madam Chair, Vice Chair, members of the Finance Committee. Thank you for having me today. Again, my name is Miles Hicks. I serve as Deputy Legislative Officer to Governor Moore, and I'm here today to urge a favorable report on Senate Bill 476, Workers' Compensation Occupational Disease Presumptions for First Responders, also known to us as the CAPES Act. This legislation would add thyroid, colon, and ovarian cancers to the current list of presumptive eligibility for workers' compensation for firefighters. Firefighters are exposed to a broad range of carcinogenic substances during the course of their work, including through inhalation, absorption through the skin, exposure to contaminated particles after a fire incident, and potentially through off-gassing from contaminated personal protective equipment. Firefighters have been experiencing an increase in thyroid, colon, and ovarian cancers as a result of exposure to these carcinogens and during the normal course of their work. And there's growing scientific proof and evidence that members of this panel will be going further detail in during our hearing. And to close, Governor Moore is committed to keeping Maryland safe and making Maryland a state that serves. Our firefighters serve our state very well, and they play a key role in our public safety. They run towards danger while most of us run away, and we are really appreciative to have them here and to support them. Again, I urge a favorable report.
Thank you, Miles. I do want to say we have all favorable testimony except one favorable with amendment. So there's no one opposing your bill. Thank you. Great. Jeff, you're next.
All right. Good afternoon, Madam Chair. Jeff Buttle on behalf of the Professional Firefighters of Maryland. We're the state level affiliate of the International Association of Firefighters and represent a little over 10,000 active and retired firefighters across the state of Maryland. We're here in support of this bill today. In my written testimony, there are three kind of important points. First, it's the medical data, kind of a summary of that goes over the support for adding these three cancers. I also included a chart that lists other states and what they're doing, so you have a comparison and an analogy. And then finally, if you really want to dig into the weeds, we have all of the links to all of the medical cases and citations if you really want to get into that. I did want to mention, each year we have our IFF Fallen Firefighter Memorial Ceremony each September, where we honor the firefighters that have died in the line of duty from the previous calendar year. And on average, between 65 to 75% of the firefighters that we're placing on that memorial wall are of occupational cancers. So this is something that's really impacting our profession. And these are occupational, the names that are being added are occupational cancers that are recognized by either the state or local government. It kind of varies across the country, but these are, recognized occupational cancers. And it's really, in our view, the greatest threat to the fire service now is cancer and trying to get a handle on it. So with that, Madam Chair, I encourage a favorable report. Thank you.
Good afternoon. My name is Raquel Cisneros, and I'm the Deputy Director for Occupational Health and Medicine at the International Association of Firefighters. The IFF is an international union representing 344,000 professional firefighters and EMTs in the United States and Canada. I want to thank the committee for the opportunity to speak in support of Senate Bill 476, the CAPES Act, to expand firefighter cancer presumption in Maryland to include thyroid, colon, and ovarian cancer. Cancer is the #1 health issue facing firefighters. Firefighters have an increase in cancer incidence and mortality compared to the general population. Due to the overwhelming data from research studies, the International Agency for Research on Cancer reclassified the occupation of firefighting from possibly carcinogenic to a known human carcinogen. In 2019, Maryland passed a law that covered several occupational cancers as presumptive diseases for firefighters. However, presumptive legislation must reflect the latest science to further protect firefighters. There are studies and evidence linking thyroid, colon, and ovarian cancer to known toxic exposures from firefighting. Research indicates a 2-time increased risk for thyroid cancer in firefighters given their occupational exposure to dioxins, formaldehyde, diesel exhaust, benzene, PFAS, and flame retardants. Multiple studies found elevated colorectal cancer incidence and mortality in firefighters. These increased rates of colon cancer are a result of exposure to arsenic, asbestos, formaldehyde, and other known fireground carcinogens. While there is a smaller sample size for female firefighters, there is sufficient data to support the elevated incidence and mortality of ovarian cancer is due to regular exposure to endocrine disrupting chemicals, asbestos, and benzene in the fire environment. In conclusion, the IFF supports passage of Senate Bill 476, and I thank you for the opportunity to speak to all of you today on this important issue.
Thank you, Raquel. Do I have any questions for this panel? Senator Plassmeyer.
Yeah, and it's either one of you could answer this. Raquel, you just said about all the different terrible things that people breathe, and that's in a fire. Are there any aims to try to get rid of a lot of those things, or is that just in general what we deal with every day, but it's not on fire?
You mean the list of chemicals that I
Right.
So these are commonly found in the fire environment, but a lot of them are components of building materials. They could be breaking down and becoming this in the combustion byproduct as well. So they're definitely in the regular environment as well. So things like formaldehyde and flame retardant,
Okay. Yeah, I'm
and
just
PFAS.
wishing that when things burned up, they didn't emit these terrible things. But we did get rid of that foam, right? A couple years ago.
Yes, ma'am.
Okay, thank you.
Seeing no other questions, that ends this panel. As I call the next panel up, I just want you to note we're going to start from the left, my left, your right, and come down the row. So we don't have to worry about somebody waiting, who's next. We're going to make this go really quickly today. James Lanier, James McAllister, Janelle Norton, Kenneth Berman, and Brianna January is favorable with the amendment. But if you all come up to the table, please. Brianna, I'm going to ask you to go last.
Yes.
So if you'll go to this end, because you're favorable with amendment. Okay, that's great. Got it. So James, you're going to start.
Yes, ma'am. Madam Chairwoman, Madam Vice Chair, members of the Senate Finance Committee, my name is Jim Lanier and I'm here on, I'm sorry. Madam Chairwoman, Madam Vice Chair, members of the Senate Finance Committee, my name is Jim Lanier and I'm here on behalf of the Maryland Association for Justice. The MAJ is a specialty bar association whose members represent and advise injured workers on workers' compensation claims. We ask for a favorable report.
Kenneth Berman, I represent and have represented for over 40 years firefighters in the state of Maryland. And I just want to give a very brief historical background. I will take up about 30 seconds. What happens is that a lot of times the materials and the asbestos comes that wasn't there 40 years ago when we passed this presumption. So given the latency period, what Senator Klausmeier was talking about, getting rid of some of those materials, we see different types of cancers than we did when we first passed it in 1980. So what this does is basically keep up with the medicine and what we are seeing in the latest studies about firefighters and their exposures. Thank you.
Madam Chair, Jim McAllister from the Maryland Association for Justice. It's my understanding nobody's speaking against this bill, so I'm going to do what I do best, which is shut up, lest I persuade somebody to stand up here and say something I don't want them to. I don't want you to hear.
You can just say me too. That works.
Me too and me three. Thank you.
Madam Chair, Madam Vice Chair, Brianna January with the Maryland Association of Counties. We are the ones support with amendments committee. We understand that this is a priority bill for the administration and the legislature. Counties are concerned with the fiscal impact of the bill, which the fiscal note does say is potentially significant. So we are seeking some state aid to help offset the cost for counties, and we encourage a favorable report with that amendment. Thank you.
Much. I think I called Janelle Norton. Is she here? Maybe not. Maybe she's not here. Thank you all very much. I appreciate your adhering to the time. That ends the hearing on Senate Bill 476. Next, we're going to go to Senate Bill 216. We have Michael Burns, and his panel includes Maureen Quinn. Mr. Burns, is there anybody else you want for the panel signed in? No.
No, Madam Chair, there is not. Chair Bidle and members of the committee. Senate Bill 216 will increase the penalty for an employer who fails to obtain legally required workers' compensation insurance from the current maximum of $10,000 to an increased maximum of $25,000. Senate Bill 216 is a Moore administration proposal. It is also a product of our interaction with the Senate Budget and Taxation Public Administration Subcommittee last year, and a report filed by this agency included with your written testimony pursuant to the Joint Chairman's report regarding the issues of penalties for failure to comply with Maryland law and workers' compensation insurance. So it is in reality a child of the Senate. Senate Bill 216 increases the penalty for failure to carry workers' compensation from the current $10,000 to a $25,000 maximum, and reflects the administration's concerns with the current low and ineffective penalty. Senate Bill 216 is a moderate bill, and it also furthers this administration's goals of protecting the health of Marylanders and the governor's commitment to social justice in this state by protecting Maryland's workers. The Uninsured Employers Fund has agreed to an amendment to the bill with the Workers' Compensation Commission to clarify that the WCC maintains its discretion to reduce the amount of the penalty to a lesser amount up to the proposed new maximum of $25,000. Chair Maureen Quinn is here today to testify regarding this. We sincerely thank Chair Bidle for sponsoring this Moore administration legislation and request a favorable report for Senate Bill 216 as amended, please. Thank you.
Madam Chair, Madam Vice Chair, members of the committee. I'm Chair Maureen Quinn of the Workers' Compensation Commission. I have delivered the proposed amendment to the members in my uploaded file. I have paper copies, however, if you wish to have one. We hope to make this the shortest bill hearing of the day. I'll just simply say the purpose of this amendment is to preserve the commissioner's ability to hear evidence and tailor the fine to the gravity of the offense. I would just remind everyone that we did agree to this, so I need say nothing else other than to answer your questions or reservations.
Thank you, Chair Quinn, and we do have your amendment.
Thank you.
We'll certainly consider it. Do I have any questions for this panel? Thank you both very much for being here.
Thank you.
Thank you, Chair Bidle. Thank you, members of the Finance Committee.
Next, we have James Lanier and James McAllister.
Again, Madam Chair, members of the Senate Committee, again, my name is Jim Lanier on behalf of the Maryland Association for Justice. The MAJ supports any action that will encourage employers to obtain workers' compensation insurance. So we wholeheartedly ask for a favorable report of this bill as well.
Good afternoon, Madam Chair. Jim McAllister, I'm from the MAJ. Let me just explain how the UEF works. So you get hurt on the job. The UEF, and there's an uninsured employer, the UEF doesn't pay until you go to a hearing. So during the month or 2 or 3 months you're waiting for a hearing, your client has no lost wages coming in. We need to encourage employers to buy insurance. When employers think they can get away with not buying insurance, it creates an incentive not to do so because they can bid jobs at a lower rate than the people that are paying the insurance premiums. This is a great bill because it encourages responsibility to rest where it ought to and has consequences. Because so often we see these UEF cases and the employer comes in and walks out of the courtroom with virtually no consequences whatsoever, leaving the state of Maryland and the UEF to pick up the tab. And most importantly, leaving injured workers having to wait 2 or 3 months for a hearing. And then once the order is entered saying pay the lost wages, the employer is ordered to pay, they have to wait another 30 days till the UEF pays. So if you get hurt on the job and you have an uninsured employer, you're going to wait 3 or 4 months to buy groceries, to pay your rent because of somebody who didn't do what they were supposed to. This bill is great. H.L. Mencken once said, a conscience is a little voice that tells you somebody might be watching. This is a conscience that these uninsured employers need. Thank you.
Thank you, Jim. Do I have any questions for this panel? Thank you very much. That ends the hearing on Senate Bill 216. Next, we have Senate Bill 234. We have Alexis Braun. I think.
Hello. Good afternoon, Chair Beidle, Vice Chair Klausner, members of the committee. I'm Alexis Braun. I serve as the Director of Policy for the Department's Division of Unemployment Insurance. I'm here today to testify in support of Senate Bill 234. There are approximately 140,000 federal civilian employees with work sites in Maryland. Of those employees, approximately 35% would be furloughed rather than accepted in the case of a federal government shutdown. Those individuals are eligible for unemployment compensation for federal employees or UCFE benefits from the department during a federal government shutdown, but they are held to the same requirements as other UI recipients, including, and most relevant to this bill, the requirement that they be actively seeking work. Unique to these claimants is that they may be subject to certain ethical standards relating to their conduct while being furloughed, which may include rules regarding outside employment or seeking outside employment. Maryland law permits the Secretary of Labor to exempt certain UI claimants from the active search for work requirement, but it does not include a provision which expressly exempts these furloughed federal civilian employees from the requirement during a full or partial shutdown, even though they're similarly situated. This bill would expressly permit the Secretary of Labor to waive the active search for work requirement for furloughed federal civilian employees during a full or partial government shutdown due to a lapse of government appropriations. This would have a positive operational impact on the agency by easing the administrative burden on the division during federal shutdowns, as well as allow the division to more easily and quickly provide benefits to federal civilian employees affected by the shutdown who remain work attached. The department was not anticipate any impact on expenditures or revenues as a result of the bill and asks for a favorable report from the committee on this bill. That concludes my testimony, but I'm happy to answer any questions you may have.
Thank you, Alexis. Do you have any questions? It's a very good bill. Thank you for the department for bringing it. No questions. That ends the hearing on Senate Bill 234.
Thank you.
We have Senate Bill 104, Unemployment Insurance Modernization Act of 2024. We have Senator Washington from the committee. Do you have anyone else to bring up with you?
Yeah, Brian Wivel.
Is he here? Here we go. Thank you, Brian.
Thank you, Madam Chair, members of the committee. For the record, Senator Alonzo Washington here to present on Senate Bill 104. Our employment system is central to countless families and businesses during the economic downturns. So many of our citizens rely on this system to give them enough money to keep a roof over their heads, food on the table, and be able to look for one another job to be able to look for another job that is adequate for them. However, this system becomes more and more outdated by the day. With many of its metrics set decades ago and not reflecting the current monetary needs of our tax bases. As things stand, there is a minimum weekly benefit of $50 and a maximum of $430, which has proven to be little for those who rent or those who live in more expensive areas of our state. These numbers were established in 2010, over 14 years ago, and have not been changed since. And thus, I'm proposing a piece of legislation to chain the benefit amounts to wage inflation to better reflect what our residents need here in the state of Maryland. Furthermore, our fund is running into solvency issues, which need to be rectified for the benefit of our state. The rate that we have in our state is sitting at an abysmal 0.85 when it needs to be more at or above 1.0 to receive federal funds without interest rates. Thus, in our current state, we are doing ourselves and our constituents a disservice. Now is the time to change this by updating these numbers and changing them to the inflation so that we don't have to fight over the livability of our constituents every 3 or 4 years or leave them abandoned with no increases as we have done in the past decade. Maryland is experiencing record low unemployment claims and at this moment, and thus is a golden opportunity to fix this broken system. Passing these much needed reforms now will make it so that when the economy hits a recession and our workers are laid off, they have a robust state to fall back on. We need to show that we care about our future and our constituents by increasing the payments they will receive and sources of funding during these prosperous times. Our average tax UI rate is 15th in the nation, and our taxable wage base ranks at an abysmal 7th lowest. We cannot leave money on the table when our constituents are living through higher costs of living. We have to be there for our residents when they need it most, as is our state's duty. For these reasons, I respectfully request a favorable report on SB 104. Thank you, Madam Chair.
Thank you, Senator. And Brian, I'll hear your testimony.
Thank you, everyone, very much. My name is Brian Wyville with the Maryland State and DC AFL-CIO. To repeat what the senator said, now is the time to take on this bill. It has been over 30 years since President Donna Edwards of the Maryland State and DC AFL-CIO sat on a joint task force in which they agreed, both business and unions, all sitting together at the table along with legislators, that the average weekly wage for unemployment insurance should be set to 2/3 of that average. It is now 30 years later, and we still have not made those proper updates to get to where this bill would bring us today. So I'd repeat that now is the time to do this, because it's now been approximately 2 years since we received the Upjohn Institute report that said this is what we need to do to make sure that Maryland's UI Trust Fund is fully funded and that we are able to hit that annual high cost multiplier that allows us to borrow interest-free from the federal government without incurring further costs on our UI Trust Fund. Additionally, as the senator said, the taxable wage base that Maryland has is 7th lowest in the entire nation. I'll say that a different way, is the 44th lowest in the entire country. There are 44 other states that have higher taxable wage bases than we do. And ultimately, I will say this bill does it all. For all of the different concerns, both those of labor and of business, this bill has answers and solutions. If you are a business and you are concerned about economic downturns negatively impacting your business, this bill additionally includes provisions that would decrease the total number of schedule changes that you could go through, so you are not slapped with large changes to what you are expecting to pay for UI for your workers. So if you are in favor of a strong and robust unemployment insurance system for businesses, if you're in favor of one for workers, we encourage you to vote a favorable report on SB 104.
Perfect, Brian. Thank you. Do I have any questions for this panel? I see no questions. Thank you both very much. So now we have our unfavorables. We have 5 unfavorables. Remember, we're gonna start from the left. So whoever wants to be first, my left, your right, you should start closest to the podium. Kelly Locklear, Andrew Griffin, Michael Halloran, Bill Zorsch, and Brianna January.
This is the first seat.
Love it. Thank you.
Honorable members of the committee, for the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are in opposition to this bill. And actually, for the record, and you just heard a little bit about the piece of legislation, we do support some of the things in it. So we like the fact that you can't shift 2 tables to assess the rate in a 1-year period. We like that the look back period is longer. We think that that can help some industries. So there are some things we like, but it would be disingenuous for me to come up here favorable with amendments, because we have been long concerned with increasing the UI benefit or lengthening it. And the reason is because it results in individuals staying on it longer. This results in higher taxes, fund solvency issues, and at a time when we cannot find employees, we find it inappropriate. And in fact, the study bill that passed in 2021 that was commissioned by the Upjohn Institute actually supported the claims that I'm talking to you about. So we definitively know that individuals will stay on unemployment insurance longer, and that is our number one issue. I'd also point to in that study, it said that when you're looking at potential revenue sources, if you're going to move forward with increasing or lengthening the benefit, you may want to look at an additional employee tax to do so. So I want to throw that out there. And then finally, like all policies, this committee sees this is not going to happen in a vacuum. So at a time the state's looking at revenue sources right now that impact businesses in a variety of ways, you have family, you have minimum wage, you have paid sick leave over the years. Again, we would just urge you all to allow the advisory committee to meet that has not met now for about 4 years, something like that. And we urge a unfavorable report. Thank you.
Andrew?
Thank you, Madam Chair, members of the committee. For the record, Andrew Griffin here on behalf of the Maryland Chamber of Commerce in opposition to Senate Bill 104. I will meet to the things my friend Kaylee said. I think the only other thing I will add is according to U.S. Department of Labor data, Maryland employers pay what is, I think, 12th best in the country for average unemployment insurance remittance per employee. It's about $417, which is still higher than all of our regional neighbors. So while we do have one of the nation's lowest low tax rates and one of the nation's highest high tax rates, so big variable there, Maryland employers are still paying a lot more per employee in unemployment insurance tax than most other states. I think that's really important to keep in mind. This bill will double the taxable wage base on employers. That means double the tax on that employers are paying. In addition, also to doubling the weekly benefit amount roughly, which, that's a in out, it's a math problem, right? If we need to solve a fund solvency issue, doubling the amount going out while simply doubling the amount coming in, I'm not sure it matches up perfectly. So there's a big conversation to have here. There's a lot of things that can be done to reform the system. I think, certainly we're willing and happy to have that conversation. It's just certainly hard to do in 2 minutes at a table here with you all, but appreciate the opportunity and urge an unfavorable report on Senate Bill 104.
You did a good job in your minute and a half. Thank you. Mike?
Madam Chair, members of the Senate Finance Committee, for the record, my name is Mike O'Halloran here today on behalf of NFIB. Obviously a me too to my friends in the retailers and State Chamber of Commerce. Talking about rankings, I know the proponents were talking about rankings to bolster their arguments. I'll use one of my own. According to the Tax Foundation, the state of Maryland ranks 47th when it comes to business taxes. So certainly putting something of this magnitude on top of that. Granted, there may not be much room to move, but we'd certainly be moving in the wrong direction when it comes to the business taxes that we level on our state's job creators. And one last thing I'll point out, as we talk about revenue issues broadly, the structural deficit that we find ourselves in, look no further than the fiscal note, and you'll see that increased employer contributions to the unemployment insurance trust fund also decrease employer federal income taxes as a deductible expense, which therefore reduces state and local income tax revenues. Suffice to say, there's a lot in this bill, a lot to be discussed. The talk was about the Joint Oversight Committee. I do believe the last time they met, I wasn't even a father. So I certainly would encourage as a first step to get that group together. But we do oppose the bill and respectfully request an unfavorable report.
Good afternoon, Madam Chair, Madam Vice Chair, esteemed committee, Brianna January with the Maryland Association of Counties in respectful opposition to SB 104. We share a lot of the same concerns that my colleagues have already expressed, but county concerns really come down to simple math. Under the bill, the weekly minimum benefit would increase more than fivefold and the maximum would more than double. This would pose a real challenge for county governments, especially considering the precarious financial situation that our local governments find themselves in. We are open to having conversations, and we've started to have some with the House sponsor over across the street. And it sounds like maybe there'll be some sort of joining of colleagues to continue these conversations, but this bill's a little bit before it's ready. With that, we urge an unfavorable report. Thank you.
Good afternoon, the chair, members of the committee, Bill George with the Maryland Municipal League here in opposition to Senate Bill 104. Jumping on what my colleague Brianna from the counties talked about in terms of the payout increases, the reason that's particularly relevant for local governments is that we're a bit unique in the employer world in that we are reimbursing employers. So we don't, our municipal and county governments don't pay in regularly through a tax. Instead, we reimburse the UI trust fund when successful claims are made by former employees. So for every dollar that the claims go up for payouts to UI claimants, that's an extra dollar that a municipal or county government needs to pay. So I want to make that very clear. This is so, you know, while some of the business community may be looking at the wage base aspect, we're actually more interested in the payout portion because that's the part that directly impacts what municipal and county governments pay in reimbursements dollar for dollar to the UI trust fund. So in a quick poll of some of my members, we have 160, so I didn't hear back from all of them. We're looking at in excess of $100,000 annually being paid out in UI reimbursements to the state. Brianna articulated that could be anywhere from 2 to 5 times more based on what's written in the bill in actual dollar for dollar payments from local governments. These come at the expense of all the essential services we provide, which I know many of you are already aware. So we completely understand that there's a valid argument for making alterations to the unemployment insurance system, and we welcome the conversation that looks to seek the balance between those that need it and the employers that pay into it. But as it stands, MML asked for an unfavorable report on the bill. Thanks.
Thank you. We have a question from Senator Reedy.
One question to one person, either Kaylee or Andrew. Why hasn't it met in 4 years, the committee? It seems like that would be something ought to meet like every year or two. You answer.
What? Why am I stuck with this? I'm not clear to be certain. Obviously, there was a global pandemic situation, so that was certainly a part of it.
Yeah, if only there was some way to like get us all together and
maybe like Zoom or something.
Yeah,
I don't know. That would be great if we could meet, though.
Is that literally the excuse?
I don't know.
I mean, it's not your fault.
I'm honestly
asking.
not
Like,
clear.
Who's in charge? All right. It just seems like that would be a good
My
idea.
understanding is there's a new subcommittee chair on this side, something like that. I don't want to throw him under the bus, but.
All right. Really? Okay. Okay. Thank you.
Senator Reedy, thank you for your question. That ends this panel. I don't see any other questions. Oh, Senator Hershey.
Thank you, Madam Chair. And I got the one question rule as well. Mike, if I could ask you quickly a question. One of the things I'd say that many of the things that we learned, but one of the things I certainly heard very often when we went through the pandemic and layoffs that occurred and people applying for unemployment insurance through the Department of Labor, when they got upset that they weren't getting their benefits quick enough, they all claimed, I've been paying into this for all these years, I want my money.
Sure.
Wasn't necessarily accurate.
No,
Right, the employees are not the ones paying into it, but the employers are paying into it. So if we look at this type of reform to increase benefits and maintain the solvency, are there any states that require employees to pay into the unemployment insurance trust fund?
There are actually, as a matter of fact, I believe New Jersey and Pennsylvania both are 2 states, and coincidentally enough, the Upjohn Institute, the report, one of their recommendations was having employees also begin paying into it. Obviously the state has plotted that course when it comes to paid family and medical leave insurance. And so I just for the good of the body, I mean, that was a recommendation from this report that's been cited.
So it's not totally out of the question. And as you mentioned before, if we're already the 7th most expensive state to do business in, these types of increased taxes are just going to make it more difficult for us to remain competitive around surrounding states. So I appreciate you letting me know that the Upjohn report did suggest that employees maybe kick into this a little bit as well too. Thank you very much. Thank you, Madam Chair.
Thank you. And Senator Klaasmeier.
Yeah, I just want to address the reason there have been no meetings. But I mean, we had several meetings during the pandemic. Okay, we did that. the pandemic was over last year, there was a bill put forth. And the Department of Labor said, can we just put it on hold and we're gonna look at it? We're trying to get a breather here right now. So I don't know where, I see where the secretary, is she here or I mean, okay, so we can ask her what she feels about the bill. And then we can just take it from there. And my good friend, the chair of UI, can take care of it from there.
Heavy weighs
And I'm
weighs the
gonna,
crown,
I'm
sir.
gonna miss it immensely.
Sorry.
Anyway, that's what's been going on, so. Not like we are ignoring it.
I see no other questions or comments from the committee. Thank you to this panel.
Thank you, Madam Chair.
Our secretary Portia Wu is here. Alexis Braun and Jason Perkins Cohen, all with information for us.
Good afternoon, Chair Bidle, Vice Chair Klausmeyer, and members of the committee. I'm Portia Wu, Secretary of Maryland Department of Labor, joined by the Deputy Secretary, Jason Perkins Cohen, and Alexis Braun, our Head of Policy, who are here to answer questions if needed. This bill tackles some critical problems, and we're grateful for Senator Washington's leadership. As has already been discussed, the UI system faces some structural challenges and is long overdue for some updates. I will note that the marginal solvency of our fund means that when we hit things like a serious recession, that can have very outsized effects on employers, as well as workers. So for example, during the pandemic, most employers are at the lowest wage rate on any given table. So contributions for most employers, they went from table A to table F, or $25.50 per employee per year to $187 per employee per year. So it was a very big increase. And were it not for the infusion of over $800 million in ARPA funds in 2022, we would have remained at table F. In addition, the system is very regressive. So if one company has a worker making $10,000, another has them making $100,000, they're paying the same insurance or tax premium. But when the low wage worker gets laid off, they get a benefit of $105 a week. The $100,000 worker gets a maximum benefit of $430 a week. The Upjohn model provides some useful guidance. There does need to be some updating. We're working with Federal Department of Labor to get that information to you to make decisions. Finally, I'll just close by saying we believe any approach should be transparent, equitable, and predictable. We should simplify the program where possible. And also, I want to note that federal administrative funding for the program has declined over the years, but fraud has shot through the roof. So relying on federal funding alone is not going to sustain our costs over the long term. Some states allow for administrative fees. We're happy to provide information about that. We look forward to working with the bill sponsors and committee and happy to answer any questions.
Are you all going to testify or?
Just for
answer?
questions.
Thank you very much. So I do have a question. Does anybody else? Do you have a good one? Okay. Madam Secretary, first, thank you for being here. And it does look like this is something we need to investigate further. But you just said the lowest paid workers receive $100 a week. Is that minimum wage or what? Because minimum wage, if you're working 40 hours, is now $600 a week.
So that's an example of the benefit. So I did like if I make $10,000 a year and I get laid off, my benefit will be $105 a week. Jason is making $100,000 a year. His benefit will be the maximum of $430 a week. But because our taxable wage base is so low, the amount the employer is paid in tax is exactly the same. So basically, you're an insurance expert, Madam Chair, you're paying in the same premium, but some people are getting much higher benefits out of it because it's replacing part of their wage. So frankly, what it means, honestly, is that the cost is concentrated on smaller employers with a lot of lower wage or part-time workers. And so thinking about the taxable wage base, you probably want to think about how to spread it out more over, a broader range.
Sounds like a work group or an oversight meeting. Thank you very much. Do we have any other questions for this panel? Thank you for being here. We appreciate it. That ends the hearing on Senate Bill 104. Senate Bill 750 Labor and Employment Workmen's Compensation Exceptions to Exclusivity of Liability, and it's Senator Quarterman. Is he here? Okay, Senator, you have a panel? Ms. Fry, okay, thank you very much. And Senator, you have as much time as you need.
All right. Thank you, Chair Bidle, Vice Chair Klausmeyer, members of the Finance Committee. For the record, Senator Paul Quarterman, District 2, representing Washington and Frederick counties. Thank you for the opportunity today to present Senate Bill 750, Workers' Compensation Exemptions to Exclusivity of Liability. Before we get too far into this, it should be noted that we already had an amendment drafted. It's been uploaded, should be available under your testimony. The main thing in there is it took out the word injury. That was supposed to be out originally. And so it removes that to make that a little bit more narrow, as well as it also is only applicable in the event that an employee is killed and that the employer is deemed to have acted in a deliberate intent causing the death. So basically, the employer would have to be found negligent in the causation of death for the family to pursue a claim of compensation. That being said, in June of 2022, the Washington County community suffered a tragic loss when Mark Allen Fry, Charles Edward Minnick, and Joshua Robert Wallace were gunned down and murdered at their workplace by a disgruntled employee in a workplace mass shooting. The shooter fled the scene only to be apprehended following a shootout with the Maryland State Police, where State Police Detective Sergeant Philip Martin was shot and wounded. Fast forward to 2023, the families of the 3 murder victims were informed that this killer would not receive any prison time for his confessed crimes. Instead, he was deemed not criminally responsible for his actions, and as such was committed to Clifton T. Perkins Psychiatric Hospital. The families of the victims feel that there were plenty of alarming and disturbing warning signs that led up to this horrific incident. Additionally, they feel that the employer did not do enough to prevent this from happening, as concerns were brought forth to the employer, and as such, there was negligence in the workplace. However, as the committee is aware, workers' comp provides only the one-time payment in the event of death. However, permanent disability provides payments to an injured employee for life. I guess our question would be, what is more permanent than death? How is the financial void filled for surviving family members? The individuals killed had days, years, decades of employment in front of them, which would translate into decades of earnings for their families. So if Senate Bill 750 were to pass, it would allow a surviving spouse, child, or dependent of a deceased employee to bring a claim of compensation and bring an action for damages against the employer if the covered employee was killed as a result of, again, suspected deliberate intent. In this very tragic situation, the families of the victims deserve to have their concerns heard before the judiciary and have the validity of those claims adjudicated in the appropriate manner. Thank you for your consideration. I respectfully ask for a favorable report on Senate Bill 750.
Okay. Good afternoon. Excuse me. My name is Angie Fry. I'm the widow of Mark Fry, who was killed in the incident that Mr. Quarterman or Senator Quarterman just addressed. I'm here to provide favorable testimony for Senate Bill 750, which adds provisions for the act of one employee killing another and adds verbiage regarding negligence when a company has prior knowledge of suspect behavior and negates any action that would have prevented harm to their employees. Maryland laws established during the Industrial Revolution of the 1920s allow employer negligence and deceit to hide behind a shield of workers' compensation insurance, which the state of Maryland requires them to carry in exchange for it being the whole remedy in any workplace injury. No, we no longer live in the same world of our predecessors who set forth the laws that currently govern the violence and lack of respect for life that we see. A murder victim's family has no recourse against an employer who turns a blind eye and permits, provokes, and provides the perfect platform for murder. There are no provisions in your current law for one employee killing another employee. Employers such as Columbia Machine need to be held accountable for failing to take action to prevent, discourage, or avert dangerous behavior in the workplace. While the killer is coddled and protected, we, the victims, have no recourse for the heartache and trauma inflicted upon us by Columbia Machine and the laws of the state of Maryland. We are not employees of Columbia Machine, and we didn't do anything wrong. And yet it's the victims that are being punished. Laws need to be modernized and victims' feelings need to be taken into consideration. Current Maryland law permits the employer to cause intense emotional distress, prevents civil action, covers the fraud that they perpetrate, and the lies that they covered up. I have not only grieved for the loss of a husband, but I have also been forced to fight battles I should never have to fight. My testimony today far exceeds the 2 minutes I have been allotted to speak to you. A full written statement has been uploaded, and I hope when you read it, you'll understand the challenges I faced and vote a favorable for Senate Bill 750. Thank you.
Thank you, Mrs. Fry, for speaking with us, and we are very sorry for your loss.
Thank you.
Do I have any other questions from this committee? No other questions. Thank you, Senator Quarterman, for the bill. I have Jim Lanier and Jim Alexander.
Again, it's James Lanier on behalf of the Maryland Association for Justice. We are also asking for a favorable report. When you handle these type of claims, these are the worst ones because there's only so much you can do. But what the MAJ wants to point out with regard to what happened to the Fry family and to Mrs. Fry personally is that there is a distinction between an employer and an insurer. So this change, and it's literally the change of really one word, or to and, to allow to file both an action directly against the employer and to file the workers' comp claim. When we have cases which you can go after the negligent at-fault party, the insurer gets a lien. So whatever they pay under the workers' comp claim, if Jim and I recover against the at-fault party, like in a most common is a motor vehicle collision. You're driving a work truck, you get rear-ended by somebody, you sue them, you get a recovery from the at-fault driver. You have to honor the lien. You have to repay the insurer for what they paid in benefits under the workers' compensation claim. This change in the statute doesn't alter that. We would still
Association for Justice. What brings us here today is something called the grand bargain. When they adopted workers' comp at the beginning of the 20th century, labor and employers got together and said, listen, what the current system is no good. You have to sue your employer if you get hurt on the job. They can say you were contributorily negligent. Maybe you can't prove the employer was negligent, and you got to wait a year or two to get to trial. So let's come up with a system. Especially at the early on in the Industrial Revolution, they were finding out that people were getting injured, that takes care of people and their families, gets them compensation right away, gets their medical bills paid right away, so that they can get back to work, keep supporting their family, and be protected from the adverse financial consequences of a workplace injury. And these are the good actors. These are the employers that are just merely negligent. These are the people that rear end people because they're texting. These are the people that spill something on the floor and don't clean it up, because that's what negligence is. And so the employer said, look, we'll buy insurance to provide these benefits and there'll be no fault benefits. So nobody gets to say, well, Mr. Employee, you weren't looking where you were going, so you slipped and fell. It's all your fault. So these are the good actors. But built into the original statute is an exception that says if you commit an intentional act as the employer, you are not entitled to that protection. The employee has the election, the option to sue either the bad actor or to collect workers' comp. And this bill makes that better because under the current system, you have to give up your right to sue, to hold the employer accountable for what they've done as a result of an intentional act because you're starving and you need the workers' comp benefits right away. Let's let them have both. Let them sort it out and reimburse the workers' comp care, but don't penalize the victims by withholding the right to hold the wrongdoers accountable. These are intentional acts, and willful act is any damn fool knows it was wrong. It's not a mistake, it's willful. And that's the protection against lawsuits in every case, other than the most serious.
Thank you. Do I have any questions for this panel? No questions from the committee. Thank you both very much.
Thank you.
Next, we have some unfavorables. Carmine D'Alessandro, Julie Murray, Ashley Smith, and Michael Daly. Mr. D'Alessandro, you can start when you're ready.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. My name is Carmine D'Alessandro. I am Chief Legal Officer for the Chesapeake Employers Insurance Company here on behalf of both Chesapeake Employers and I with in respectful opposition to Senate Bill 750. As you've heard me say before, Chesapeake insures about 19,000 Maryland policyholders. We also are affiliated with the Injured Workers Insurance Fund, where we oversee the workers' compensation program for the state of Maryland's 85,000 employees. I'm not going to go into the exclusivity doctrine. It's in my written testimony, and Mr. McAllister has explained that bargain as he does very well. When we're here, there are two exceptions to the exclusivity doctrine. One is if your employer fails to procure insurance, you are permitted to sue your employer or file a claim, one or the other. Or if your employer intentionally injures you, you are permitted to sue your employer or file a claim, but not both. In the facts of the case, as I understand that I just heard, there's also a provision in the Workers' Compensation Act where if you are injured or killed by a third party, you can file a workers' compensation claim against your employer for the actions of that third party. In this case, the co-employee would be a third party. And because he is a third party, you can sue a third party. So in this case, you could have had two remedies because the employee is both working for the employer, but a third party. I have to take issue with some of the testimony about being able to recoup your money from an employer. In workers' comp, the employer is the first party. We're only allowed to recoup from a third party. So if an individual will be permitted to sue the employer and seek workers' compensation benefits, we would not be able to recoup those benefits because the employer is a first party. We can only recoup from a third party. I also, the benefit of one-time payment in Maryland, a death benefit is 12 years of payment at 2/3 of the deceased average weekly wage. Again, this was not a Chesapeake or an IWIF case, so I don't know all the facts. But we're here to uphold the exclusivity, which is the bedrock of workers' compensation. And my concern is the more you eat away with it, the more it evaporates. And then you become a state like Texas that allows an opt-out and allows their employers to opt out of workers' compensation. So thank you and respectfully oppose the bill.
Thank you. Good afternoon, Madam Chair, Vice Chair, members of the committee. Julie Murray on behalf of the Maryland Defense Council. I am the co-chair of our Workers' Compensation Subcommittee. The Maryland Defense Council is the organization of defense attorneys and entities in the state of Maryland. We are here also in respectful opposition to Senate Bill 750. While we are certainly sympathetic to the facts of the case that you heard testimony on, we agree with and support Mr. D'Alessandro's testimony in that the long-standing framework of our act is for an exclusivity of remedies. The statement that was made where we should, quote unquote, I think the phrase was, let them have both, is exactly what the Workers' Compensation Act was predicated on not doing. It was designed to provide some trade-offs and some compromises in exchange for a guarantee of benefits in certain situations. We do have to oppose this bill that eats away at that framework and takes one specific narrow situation and removes it from that and puts us in a position where we now have employers and their insurance carriers unable to properly determine their liability in advance of claims. And for that reasons, and the reasons that the rest of the panel will discuss, MDC would ask for an unfavorable report.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Michael Daly on behalf of the Maryland Defense Council. As Ms. Murray and Mr. D'Alessandro said, we respectfully request an unfavorable report on this bill. We certainly adopt the reasons that were stated by both of my colleagues. It is important to remember that, and it was touched upon, but workers' compensation does provide specific benefits to an injured worker that would not be available under tort law. That's why the statute was enacted and does exactly that, protects injured workers when they would not otherwise be entitled to benefits. As a side note, as one of the proud members of the summer study, when we revamped the death benefits bill to its current state, it's important to note that Maryland's death benefits, and I'm proud to say this, provides the most extensive benefits to dependents and spouses, much greater than surrounding jurisdictions. And therefore, as Mr. D'Alessandro touched upon, the weekly benefits going up to 144 months was an extension of the amounts that would be payable to a spouse, and that can be paid over time, weekly benefits. But for those reasons, respectively request unfavorable. Thank you.
Thank you, Madam Chair, Madam Co-Chair. My name is Ashley Smith. I'm also with the Maryland Defense Council. I'm going to be very brief and just build briefly on what Mr. D'Alessandro indicated to you guys regarding the liens of possibly going forward with both a civil suit and a workers' compensation claim. I just want to emphasize that insurance companies cannot subrogate against their own insureds. And allowing a situation where that would occur would create more issues than I can think of in the short 2 minutes that I have to sit here. But the most important amongst them would be the conflicts of interest created between the insurance company and the employer, which with the way the laws are written in Maryland, they're supposed to be on the same side and they're supposed to be working together. It would also create just very, it would not put the parties involved in a good position. And like Mr. Daly indicated, they do provide significant benefits under the Workers' Compensation Act for injured workers. And while 12 years is the standard, it can be extended beyond that in the case of an injured worker's child who has like a developmental disability or something along those lines. So there are exceptions for it to go beyond the standard 12 years. Thank you.
Thank you, Ms. Smith. Do I have any questions? Oh, Senator Gall, I'm sorry.
Thank you, Madam Chair. You know, and I'm certainly sympathetic for the reasons for bringing this bill, but I mean, I was just reviewing it, and Carmine, you spoke earlier about you know, this would really fundamentally upend a major tenet of workers' compensation law, and that's that exclusive remedy. And I'm just wondering, is there any other instance in which there's an exception to that exclusivity? I mean, it sounds like this would make an exception just purely for an intentional tort committed either by both the employer to injure or kill, or an employee. And I'm not certain whether or not there's some knowledge basis there, but like, is there any other exception to exclusivity that you're aware of?
No, the two in the statute that I talked about, not
Right.
procuring insurance and an intent to lack.
Okay.
But it's still an either or, so you have to
Right.
pick. The part E of the bill talks about the co-employee being involved. That's actually covered in 9101 of the statute, where it talks about being able to file a claim because of a third party assault. So that's covered somewhere else. So to my knowledge, Senator Gall, just those two exceptions. And I think that's pretty standard throughout the 50 workers' compensation systems throughout the country, those two exceptions.
And this would potentially result in the worker getting a double recovery then, correct?
Correct.
Okay. All right. Thank you. Thank you, Madam Chair.
Thank you. Any other questions for this panel? Thank you very much for your testimony. And that ends the hearing on Senate Bill 750. And next we'll do Senate Bill 871, Senator Kramer.
Madam Chair, I'm not sure, but I may have a panel of one.
Brian Weaver. Okay.
Good afternoon, Madam
Thank you.
Chair, members of the committee, Ben Kramer, introducing Senate Bill 871, which is a pretty straightforward bill. Colleagues, currently, if an employee is working in a business where management and the bargaining unit representing those employees have a dispute that leads to a work stoppage, frequently referred to as a strike. The employees who are no longer able to collect a paycheck are not eligible for unemployment benefits. The bill before you corrects that and provides that after 14 days, if that work stoppage is still continuing, that the employee be provided an opportunity to be eligible for unemployment benefits. And it's really just that straightforward and that simple, knowing that this is a very important benefit for employees to ensure that they can be putting food on the table, that they can be making payments on the car, on the house, ensuring that they can pay for those needs that the family has during the course of the work stoppage. So it's just that simple. Also recognizing that whatever those benefits are, the employee is utilizing them and they're going back into our communities, most likely to small businesses, where the employee is buying groceries and getting those necessities for the family. So with that, Madam Chair, I'll turn it over to my extensive panel.
Thank you very much. My name is Brian Wyvil with the Maryland State and DC AFL-CIO. I want to thank the senator for carrying this bill. First, I'd start by saying that it goes without saying, but striking is a last resort. This is at the end of a long process of negotiation. It is kind of a weight of conscience that hits on workers when they decide that ultimately the step they need to take in their collective bargaining is to assert their rights and withhold their labor. So I would already like to highlight that New York and New Jersey already have this type of unemployment insurance allowance for the collection of benefits after 14 days on strike. And other states such as Pennsylvania have done case-by-case exceptions for workers that have been out on strike for certain periods of time. So this is not something new. This is something other states have and have this benefit. Ultimately, I think it's interesting. A panelist on a previous panel talked about kind of a grand bargain that was made between businesses and labor nearly a century ago. That bargain was that ultimately these systems of worker benefits would be handled by the state and not handled directly by workers themselves. It's not uncommon in European countries to have the Ghent system where workers through their unions actually manage these type of benefits and therefore are able to access them in strikes. So this type of arrangement is not uncommon in other countries as well. I would like to flag that in the fiscal note, they talk about how rare it would even be for workers to be able to use this benefits because of the 14-day requirement. We did a little bit of digging ourselves and were able to only find 3 examples in the entire last year of 2023 where workers might have even been able to claim this benefit because of that 14-day requirement. So additionally, I would like to end by saying the goal of an unemployment insurance is a stable employment market. We want to make sure that workers don't lose everything simply because they have to deal with bad faith bargaining from an employer. Thank you.
Are there any questions of the sponsor or the panel? Seeing none, I think we'll go to the end of that bill. And we're
Thank you,
going to
Madam
go
Chair.
to Senate Bill 460 with Senator Kagan is the sponsor, and she's in the room. Senator Kagan's in the room.
Hello, Madam Chair, colleagues. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. This strikes me as a really obvious common sense bill for your consideration. When I was first elected, I was taught that the first thing we had to figure out is whether there was a problem, then whether there's a solution, and then whether the solution is reasonable and affordable. And this bill answers all those questions. We have a problem in Maryland and around the country with a shortage of election judges. This solution allows people who are receiving unemployment insurance to become election judges during early voting or on election day to help make sure that our polls are covered and not have that count against their unemployment benefits. So I don't think I need to say a lot more than that, because I mean, as soon as I got that much, I just kind of said, duh. I thought it was a little bit brilliant. With credit to one of my delegates, Julie Polakovich Carr, I just want to say that there is an amendment that just clarifies, and the Department of Labor asked for this amendment that strikes some of the language that's in there. And it just says a payment to an individual as compensation for serving as an election judge for a local board of elections in the state may not be included when computing the wages required to be subtracted under paragraph 1 sub 3 of this subsection. So really that's all it does. And I'm happy to take questions. I have data, I have the numbers of shortages, but you guys are busy and so are we downstairs, and I'm happy to take your questions.
I don't see any questions for this good bill, Madam Senator. Thank you very much. That
Thank you,
ends the
Madam Chair.
hearing on Senate Bill 460. Somebody say something? And now we'll do Senate Bill 1069.
Thank you, Madam Chair. Because these files are done separately, I will again introduce myself as Cheryl Kagan, still very proud to be the senator for Gaithersburg and Rockville. I think many of you know that I have spent the last 9 years working on 911, and I have had a special focus on our 911 specialists. Together as a body, we have brought Maryland to the forefront of next generation 911. We have paid attention to funding, staffing, recruitment, retention, training, oversight, accountability, cybersecurity, geographic information system, all of the things. The one piece, or one of the small pieces, important pieces that we haven't been able to do yet is figure out how to care for the mental health and well-being of the courageous women and men under the headset. So I have brought a workers' comp bill before this committee before. My partner in the House side, Delegate Terry Hill, who served on the 911 task force that I chaired for 4 years, is proposing that we actually seek to collect data. Because without the data, we can't really come and say exactly what's happening. We've done research on what's happening in other states, but we need to think about all our first responders, our police, our firefighters, our paramedics, and our 911 specialists, who are our first responders. So the House Economic Matters Committee has referred this bill for summer study. I don't quite know how that is from a parliamentary procedure, so I'm not pushing the bill forward as is. But if that's something, Madam Chair, that you and your colleagues would consider doing so that we can really officially try to gather data. And so the vice chair and other people who are much smarter than I am on issues around workers' comp could have that information by next year, that would be terrific. And I'm happy to take questions.
Senator Kagan, I think since it's already been amended in the House, it'd be smart if we do the same amendment and then figure out who's on the work group and come back next year with some suggestions.
That makes sense to me.
So do you want me to just end the hearing on?
I
Senate Bill
think that makes sense.
1069?
I don't want to take your time.
Well, I appreciate it very much, and we'll work with the House and get that figured out.
Perfect.
Thank you.
Thank you, Madam Chair. Thank you, colleagues.
So for the rest of the people signed up for Senate Bill 1069, it's going to be summer study, and that's going to end the hearing for Senate Bill 1069. My Vice Chair, Senator Kathy Klassmeyer, Senate Bill 846, Maryland Department of Labor Unemployment Insurance Study on Actively Seeking Work Requirements. And would you like to bring up Kelly Locklear or Michael Halloran as your panel? Thank you. Michael here, Kelly here. Senator, did you lose your panel?
I did. Unless they're out in the hall.
Would you,
What's their names? Mike O'Halloran and Kelly Locklear.
Kelly Locklear. If they're not here right now, we could do 789 and then go back to 846.
Yeah.
Here they come. Hurry up.
Never miss a chance to testify in favor.
I know, isn't it exciting? Senate Bill 846, Maryland Department of Labor Unemployment Insurance Study on Actively Seeking Work Requirements. Thank you, Chair Bidle and fellow members of the Senate Finance Committee for the opportunity to present Senate Bill 846, which requires the Department of Labor to conduct a study on the actively seeking work requirements of Maryland's unemployment insurance system. In order to receive unemployment insurance benefits in Maryland, applicants must take steps to show the department that they are actively searching for work. One of these requirements is to apply or interview with an employer. For years, many businesses have been flagging the issue of ghosting, which is when a prospective employee who is currently receiving unemployment benefits applies for a job but fails to maintain contact with the employer after an interview is scheduled. Unfortunately, there is no way for businesses to identify these individuals through the Beacon system, which is in the Labor Department. Senate Bill 846 will require the Department of Labor to look at the systems in place in other states to see how we can improve it in Maryland. Reducing fraud and abuse in our unemployment system should always be a goal, and this bill will ensure that the department continues looking at the issue going forward. I ask for a favorable report on Senate Bill 846.
Good afternoon again, Madam Chair. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are in full support of this bill. And the issue of ghosting is commonplace. And yes, that is a real HR term, as you just heard. We have been trying to work with the Department of Labor under multiple secretaries and multiple administrations on this issue. And the reason is currently in the Beacon system, there is no way for an employer to actually report when someone does this. The way the Beacon system works is you actually have to have a social security number of an employee. And at that point in the process, that is not your employee and you do not have their social security number. And I'm glad to show you guys screenshots of that. I actually went through it with a couple of members of ours who explained we have no way to report this in the system. Maryland actually technically has 3 active search for work requirements, one of which must be met by applying to a job or going to an interview. But again, there is no verification going on and there's no way to report this in the system at all. So why does this matter to you? I think all of us in our conversations agree that we should eliminate fraud and abuse from the system. We have a lot of conversations here about the solvency of the fund itself and then increased taxes on businesses too. So I think it's incumbent on all of us to eliminate whatever fraud and abuse is out there. And I just also on the record want to be very clear, by no means do I think that this is happening a ton. We understand there is a place for unemployment insurance, but we should go ahead and eliminate as much fraud as possible. I'll stop there. Glad to answer any questions. We do urge a favorable report. Thank you.
Good afternoon, Madam Chair. For the record, Mike O'Halloran here today representing NFIB in Maryland. Obviously a Me Too in support of Senator Klausmeyer's bill. Appreciate her bringing this bill forward. As we spoke about Senator Washington's bill, there are a lot of changes that perhaps can be pursued when it comes to the UI system. I think this bill represents an addition to those efforts because it is an issue. Yes, the state does have the lowest unemployment rate in the country. At the same time, we want to make sure, because we're also hearing how the trust fund, is it at risk of being insolvent? Are we at risk of jeopardizing our zero interest loans from the federal government in case there is an economic downturn. All of these issues are very important, and we see this bill as being additive to those discussions and figuring out, all right, if we're going to start peeling back the layers of this onion of the state's UI program, then this should be part of that conversation. So that's why we're here in full support of the bill, and we do ask a favorable committee report. Thank you.
Thank you. Senator Ellis?
Thank you, Madam Chair. For the record, this is my first question for the day. Might be my last. But the code ghosting, this is where you said employees do not check in when they file for unemployment. I'm not familiar who's ghosting who.
So an employee, if I may.
Yes, thank you.
An employee will apply for a job, an employer will set up an interview and they will ghost that interview, or they will actually.
They don't show up for the interview.
Correct.
Okay.
Correct. Or they will actually come in and be hired, start date is set, and then that employee doesn't show up either. So those are the two ways in which an employee or potential employee ghosts.
Okay, great. Thank you. Thank you, Madam Chair.
Thank you, Senator. Do I have any other questions? Oh, no. Okay. Thank you for this testimony. We have one person virtually that's favorable, Stephanie Minsberg.
Yes, I'm here.
Can begin. Thank you.
How would you like me to begin? Describing the ghosting that I've experienced?
Yes, ma'am, that'd be great. You have 2 minutes.
Okay. I am an HR manager at a small catering and grocery store operation. It does actually, it costs money and time to post ads. We then, as the young lady said, set interviews. Hiring manager is waiting. There's several ways that potential employees ghost us. They do not show up for the interview. They could come for the initial interview, then we set a working interview. They may not show up for that. And then again, it has happened several times that a start date is set, and then they don't show up for their first day. The unfortunate part is certainly time and money has been expended on our end. But again, I think that, and having experienced being on unemployment myself very briefly, I was actually frightened that I was going to get caught. I made sure that I applied every week, did my due diligence, but no one ever checked up. So I do wish that there, from an employer's standpoint, there was some way that we could get control to report to you guys, to unemployment, when there may be fraud occurring. As it stands right now, we do not. So I am in favor of coming up with some sort of accountability, and that concludes my testimony.
Thank you for that testimony. Do I have any questions for this witness? Thank you very much. That ends the hearing on Senate Bill 846. Next, we'll go back again to Senator Klausmeier, Senate Bill 789.
Thank you, Madam Chairman. I guess according to my sponsor panel, I have Jim Lanier and Matt Pavola.
And Jim McAllister.
Oh, okay. Senate Bill 789, if you want to come up, guys.
Where come?
Okay, that way. Senate Bill 789 is designed to give the Maryland Workers' Compensation Commission the power to penalize the uninsured employers fund when the UEF fails to make timely payments to the injured workers after the commission awards medical and other benefits to be paid. Due to a decision from a case that was before the Supreme Court of Maryland, UEF versus Danner, the UEF states that they cannot be penalized for failing to make timely payments. Senate Bill 789 will supersede the Danner decision to encourage the UEF to pay awards in a timely manner. This change will ensure that the injured workers receive benefits awarded by the commission. This is especially important to protect the injured workers who have already been victimized due to an employer breaking the law by failing to have workers' compensation insurance. This bill would simply require that the UEF be held to the same rules and standards as other stakeholders. These insured employees have already faced a lack of insurance from their employer. Therefore, the injured worker requires the aid of the uninsured employer's fund. This bill will further protect such workers that have been exploited by their employers by guaranteeing that they are provided with compensation the commission has determined necessary, reasonable, and related to the worker's medical recovery and attempts to return to work. Thank you, and I look forward to the discussion on Senate Bill 789.
Good afternoon, James Lanier again on behalf of the Maryland Association for Justice. In preparation for both last week's hearing and this hearing with Senate Finance, I reviewed the written submissions by the Uninsured Employers Fund, and they focused on the fact that there is no current problem with untimely payments, and that's just inaccurate. When the commission, obviously the whole reason the UEF exists is when an employer, as we heard earlier, an employer didn't have workers' comp insurance. Worker gets injured, so they're already being penalized because their employer broke the law. The UEF is supposed to step in the shoes of the non-insured employer and pay the benefits. So then we have a hearing, commission awards a benefit, medical, money for out of work, whatever it might be, and then someone files an appeal. The UEF generally takes the position that we are not responsible for paying any of the benefits even awarded by the commission while an appeal is pending. And that is the entire problem, because an appeal could take 12, 18 months, and the injured worker is still not getting the medical benefits, is still not getting the out of work benefits, when the entire purpose of the workers' comp system is to help them get back to work. The change in the statute abrogates the Danner decision, because Danner says the current statute does not apply to the UEF, only applies to employers and insurers, which is true, which is why this change is being requested, so that the commission now has the discretion when the UEF fails to pay in a timely manner. The commission now has the ability to give penalties against the UEF that get paid to the injured worker when the UEF fails to honor their requirements to pay as the commission has required. And in the idea that they're not doing it now, I have orders from the commission, I have affidavits, and I have correspondence from UEF representatives who continue to hold the position in years past and currently that they're not required to pay while on appeal, and they always cite to the Danner case, which is interesting because even one of the orders from the commission says, despite the Danner case, you guys still need to pay. So we ask for a favorable report to fix the problem so that it honors workers' comp orders from the commission. Thank you.
Good afternoon, Matt Pavola, also with the Maryland Association of Justice, in favor of 789. You've heard testimony quite a bit already today about the fund. It's called the UEF, Uninsured Employer Fund. And one of the points you'll hear stated in opposition is that, well, they're not a party, unlike the employer and insurer, who are parties and who are subject to the penalties. And therefore, they shouldn't be treated in the same way with regard to these penalties. And as Mr. Lanier has just pointed out, the stories are legend. All three of us at this table have examples where on an appeal, the fund would not pay benefits that were ordered. So lawyers had to become creative and almost conjure up reasons to seek seek these penalties. In any event, it shouldn't be denied just because they're not, strictly speaking, a party in the sense of an employer or insurer. I might just add something Mr. Lanier said, 18 months on an appeal. That's true on a petition for judicial review, but these appeals to higher courts mean our Court of Special Appeals sometimes happen, and our Court of Appeals, and they go on even longer. So thank you. Thank you for this opportunity to testify and your favorable treatment.
Good afternoon. Thank you for the opportunity to speak My name is Jim McAllister. I'm a member of the Maryland Association for Justice and have done workers' compensation cases for over 30 years. Workers' compensation is a mission statement. It's not just the label on the building. It's a promise made by the state of Maryland that if you get hurt on the job, you will be compensated. Your bills will get paid, your lost wages will be paid, and you're going to be able to get medical treatment. Is there anybody in this room that knows whether your employer has workers' comp insurance or not that doesn't work for the state of Maryland? Nobody asked that, and it's a tragic discovery when you find out your employer was too cheap and penny wise to buy workers' comp insurance. But no, it doesn't end there. Now you have to wait for a hearing to get your lost wages paid, where if there was an insurance company, they'd write the check right away. So now it's 3 weeks later and you have a hearing. Then the employer has 30 days to pay that order. And if they don't, then the UEF owes the money. So it's now a month without a paycheck through something that was completely not your fault. Now, if you're dissatisfied with the decision of the commission, you have the right to file an appeal. Everybody does, as does the UEF. But there's something called the automatic stay provision in workers' comp that says if an appeal is filed, it doesn't stop or stay the obligation of the workers' compensation insurance company to pay, so that you don't starve to death while you're waiting for a year or two for your case to be heard on appeal. The UEF has taken the position in some cases that doesn't apply to them. And then when I was at the House, they said, no, we don't do that. I'm not here to say how bad anybody's been. I'm here to show you how good they can be. Because if you pass this and they do exactly what they said in the House, which is we pay these claims, we're not late, and we do what we're supposed to, then we're all happy. And we don't need to engage in a conversation about how bad it's been, but how good it can be for Maryland workers unlucky enough to work for an uninsured employer. Thank you.
Thank you. I actually have a question. I'm going to ask it to Jim McAllister. How many of these claims that there's no workman's comp insurance, is it because the employer was calling them an independent contractor and had them misclassified? Do you have any idea?
That's not a UEF case.
That's not UEF.
That's somebody who's not covered by workers' comp. So that's in order to file a claim, you have to be what I call an eligible receiver, which is considered to be a covered employee under the statute.
So these are employees that are documented as being employees.
Right. These are, because if they're an independent contractor, it wouldn't matter. The UEF wouldn't pay them.
Yeah. Well, there's a lot of misclassification. That's why I asked the question.
Right. But no, that's an effort to avoid having them be an eligible receiver.
Right.
These are undeniably eligible receivers who simply can't get paid enough money to pay their bills on time or soon enough to have it make a difference. Does that answer your question?
It does. Thank you, Mr. McAllister. Do I have any other questions for this panel? Thank you very much. That ends the sponsor panel. And next we have Michael Burns with unfavorable testimony.
Madam Chair, David Stesh, who is signed up to testify, is from the Office of the Attorney General. I'm here to provide not partisan testimony, but simply for information purposes, and I brought him up with me.
That's great. Thank you.
All right. Thank you. My name is Michael Burns, and I remain the Director of the Uninsured Employers Fund. The interested parties testifying in favor of this bill have indicated this bill is necessary to enact because the UEF, quote, refuses, end quote, to pay awards while appeals are pending as a matter of choice. This is not true. The UEF's triggering statute 91002 of the labor employment article does not currently allow and has not allowed the UEF to pay awards while appeals on compensability are pending. That is the reason for our refusal. This has been verified in a case mentioned called Danner from 2005, 19 years ago. The UEF does pay injured workers when appeals are pending on issues other than compensability. The bill, however, does nothing to change 91002 or remove the language that currently prevents the UEF from paying awards while certain appeals are pending. In summary, 91002 lays out the process and the timeline of how the fund pays benefits. This bill does not change that statute in any way, so it would not change the timelines by which this fund pays benefits, despite claims to the contrary. Changing such timelines would require substantial legislative changes, which would seriously disrupt how the UEF functions, operates, and cares for injured workers. We also foresee that claimant attorneys will seek large fines from the fund for the sin of following the law if this passes. Why else add a state agency to a section dealing with private parties? The UEF is not an insurance company. It is not an employer. It is a payer of last resort established by law to be the ultimate backstop if there's no one else to pay. We are not an insurance company. We are not ordered by the Workers' Compensation Commission as an insurance company or as an employer is to make payments. We get involved differently. I urge a strong, unfavorable report on this legislation.
Thank you, Mr. Burns. Mr. Stasher, are you testifying? or-
Yes, just briefly, Madam Chair, and I just want to clarify, I'm with the Office of the Attorney General. I'm here solely representing the Uninsured Employers Fund. The Office of the Attorney General has not taken a position for or against this bill. Quite frankly, this proposed bill does not accomplish what the sponsors think and hope to accomplish because it only addresses the penalty portion of 9.727.728. The UEF, whether we pay or do not pay on an appeal on compensability, has nothing to do with those sections. It solely has to do with our triggering statute, which is 9.102. That statute, there's no sought to be changed with that statute. 9.102 is aptly called payment from the Uninsured Employers Fund. So for the purpose of amending 9.727 and 7.28 to provide a certain time period when the UEF pays, this is the wrong statute. That has to be the triggering statute, 9.102, that determines when we pay that. I also want to make clear that there's a misconception in the workers' comp community. The UEF never pays benefits pending an appeal. That's not the case. It has to be pursuant to this the Court of Appeals opinion 20 years ago. That used to be the UEF's position, never pay on appeals.
Right.
The Danner decision limited that solely to appeals on compensability, attacking the validity of the order. And pursuant to 9.102, the way it was interpreted 20 years ago, the way it's still interpreted, that no change has been sought to change that statute, we're prevented from paying appeals when a compensability has been timely filed. And for that reason, we're not triggered. That's the reason. So I just want to make sure that this misconception the UEF doesn't pay pending appeals. That was the case 20 years ago. That's not the case because Danner, the court specifically limited when the UEF could pay. And this statute simply does not close that alleged loophole that you're trying to close because it doesn't address our triggering statute. Whether we pay benefits or not has nothing to do with whether or not we're subject to penalties. Thank you.
I do not see any questions for this panel. Thank you very much.
Thank you, Madam Chair.
That ends the hearing on Senate Bill 789. And next, Senator Klaasmeyer's back for Senate Bill 843.
Okay, Madam Chair, if you want to call my panel.
I sure will. Your panel is Jeff Buttle, P. Matthew Darby, and Kenneth Berman.
I'm gonna move over here. Share this. Thank you, Chair Bidle and fellow members of the great Senate Finance Committee for the opportunity to present Senate Bill 843, which updates the process for which hearing loss is determined for the purposes of workers' compensation and adds tinnitus to the eligible types of hearing loss. The purpose of this bill is to address both medical and legislative updates based on fair and reasonable standards. As the diagnosis of hearing loss and medical advancements continue to improve over time, medical science has also shown that hearing loss can occur sooner than expected due to the noise or another incident that creates exposure. Senate Bill 843 is simply trying to update the statute to reflect updates in the field by increasing the number of frequencies that must be included in the calculations for determining the compensation benefits. In addition, the bill defines tinnitus, also known as ringing in the ears, in the workers' compensation statute to better define and reflect the components of hearing loss. I am also offering two small amendments to the bill. First sponsor amendment simply fixes a drafting error that left out one part of the code that needed changing. The second sponsor amendment is clarifying and came at the request of the Workers' Compensation Commission. Thank you, and I look forward to discussion on this legislation.
Afternoon, Madam Chair. Jeff Buttle on behalf of the Professional Firefighters Maryland in support of this bill. I'm not going to get into a lot of detail because the next speakers will be able to really tell you some of the issues that we're having. But this bill is important to the firefighters. A lot of our members are experiencing hearing loss that's occupationally related, and the amendments to the statute offered by this bill would go a long way in helping to make sure that our firefighters are covered for hearing loss as a result of the job. And I also would like to for the record, the two sponsor amendments that are being offered, we support those as well. So thank you, Madam Chair.
Good afternoon, Madam Chair, ladies and gentlemen, committee. Matt Darby. I'm a practicing attorney and been representing firefighters here in the state of Maryland in various jurisdictions since about mid-1990s. I really couldn't give you a number of how many hearing loss cases I've handled, but it's been a lot. And there have been a couple of things that I've come to realize over the years, and that is this issue really is somewhat unique. I mean, the law that we are proposing is applies certainly to everyone. It's not firefighter specific, but firefighters have a unique employment in the sense that they are in an uncontrolled environment on a repeated basis with loud noise. And that loud noise is central really to the protection of the public because it's the indicator that obviously emergency vehicles are in the vicinity. And so the impact on cognitive health with respect to diminished hearing is well known, and it's important to protect our firefighters as they experience this hearing loss on an ongoing basis. One of the things that happened in the Economic Matters Committee was there was some confusion, I think, from opposition about how age is taken into consideration in our proposed legislation. And just a couple minor points. One is that I think as we have some audiologists testify in the next panel that age does not typically begin to impact hearing until later than 50. So in the bill, the age impact or age penalty, as we call it in the profession, deals with any age issues over 50. It's probably earlier than it really ought to be. We're not seeking to change that, but I want to point that out. The other thing is that compensation doesn't begin unless the hearing loss is over 25 decibels. Over 25 decibels in the bill. Actual, probably normal hearing is 20 decibels. However, what this bill does with respect to age is it does not penalize firefighters with longer exposures. It kind of reverses what we call the age penalty. So unless there are any questions with that, I would appreciate on behalf of our firefighters in Maryland, a favorable report. Thank you.
Afternoon again, Kenneth Berman, and I've been representing firefighters a little bit longer than Mr. Darby. I feel older. Briefly, just as a very quick judicial background, this arises from a case that I was involved in called Montgomery County versus Anthony Cochran, where the Supreme Court of Maryland reversed the county's attempt to say that tinnitus could never arise with hearing loss in the same claim. The Supreme Court shut the door on that and agreed with us that it could. So what this bill seeks to do, in addition to what everybody else said, is bring into line and have a coexistence between the tinnitus and the hearing loss. Because as the other panel member said, sometimes you reach the threshold of hearing loss and you don't yet have tinnitus, or sometimes you have tinnitus, but you haven't met the threshold of hearing loss. This will put the two together. It also lead to less cases before the commission. So it kind of bridges the gap and takes the second step of what the Supreme Court told us is the right way to look at this. Thank you.
Do I have questions for this panel? I do not see any questions. Thank you very much for your testimony. We have more favorables: Rebecca Jihad, Lisa Berenger, Jim McAllister, John Hall, Matt Pavola.
Good afternoon. My name is Dr. Rebecca Jahed, and I've been practicing in audiology for 32 years. When a person comes into our office for a hearing test, we're always going to test from 250 to 8,000 hertz because that's the range of speech information. But if they do come in and they report any type of noise damage, we always look at the high frequency range. We expect to see a dip between 3,000 and 6,000 hertz, and then sometimes recovering at 8,000 hertz. This is what we classify in the field of audiology as a noise-induced notch. But we pay the closest attention to 4,000 hertz, and that's what we call the noise-induced frequency. It's not unusual to have a person come into the office with normal hearing out to 3,000 hertz and have a dip at 4,000 and 6,000 hertz. The reason these pitches are the most affected actually has to do with the anatomy of our ear canal, with the ear canal being open at one end and the eardrum at the other end. And with the shape of our ear canal, it creates a resonance of sound energy that travels from the middle ear to the inner ear, and it may boost the area around 4,000 hertz, up to 20 decibels louder than all the other pitches. Therefore, hearing loss caused by loud intensity sounds has the greatest impact on 4,000 hertz. An article by the American Journal of Otolaryngology states that prolonged exposure to noise produces permanent hearing loss in the frequency region centered around 4,000 hertz, despite differences in the spectral and temporal characteristics of the noise. As 4,000 hertz is the frequency most affected by noise exposure, we urge that it be included in the formula to rate hearing loss disability in the state of Maryland. Thank you.
Who's next?
Good afternoon. My name is Dr. Lisa Berenger, and I've been an audiologist in Maryland for over 30 years. First, I would like to speak in favor of adding 4,000 hertz to Maryland's hearing loss disability formula. Maryland's current calculation is based on the 1979 American Medical Association's formula. Back in the time, it made sense to limit the disability only out to 3,000 hertz because the technology of the day was not that high in frequency. Things like telephones only went up to 2,800 hertz at the time, so it made sense to limit things to what was available. Now, things like, telephones, televisions, they carry much higher frequencies. The 1979 formula was actually an update of a 1959 formula, which only went up to 2,000 hertz. So there is precedence for increasing the frequency range with increasing, technology and knowledge about acoustics. More modern formulas like that released by the National Institute of Occupational Safety and Health in 1997 do include 4,000 hertz in their formula. The Veterans Administration includes 4,000 hertz in their formula. And when we're evaluating for noise-induced hearing loss under Occupational Safety and Health Administration guidelines, 4,000 hertz is one of only 3 frequencies that they check to see if noise-induced hearing loss is occurring. Since 4,000 hertz is included in how noise-induced hearing loss is defined, it would make sense to include it in the calculation of hearing loss disability. Also, I would like to speak in favor of adding tinnitus as a recognized disability. The VA administration recommends 10% disability for tinnitus. The American Medical Association recommends a 5% disability for tinnitus. I tested one veteran who said that he turned to drugs and alcohol because his tinnitus made him remember things that he would rather forget. Given this, how disabling tinnitus can be, I would urge the recognition of tinnitus as a compensable disability. Thank you.
Good afternoon. My name is John Hall. I was a prosecutor in Prince George's County Narcotics. Since then, I've served as I've I serve firefighters and police officers in the state of Maryland for work-related injuries. I can tell you between Mr. Berman, Mr. Darby and I, we've tried thousands of these cases. The interesting thing about this statute is that we wanted to point out that OSHA is the regulatory commission over hearing loss and what the guidelines should be for safety. In OSHA's own guidelines, they recommend 4,000 hertz. The audiometric notch that the doctor's speaking of, right now we go 500 to 3,000. The audiometric notch is 4,000 to 6,000. We're not asking for 5,000 or 6,000. We're just asking for 4,000 hertz to be addressed. When we appeared before the economic matters, our opponents to this bill testified that these claims are accepted. They're not. I've tried as many or more cases of hearing loss as either of my colleagues that are here. They're always denied. I've never had a case for hearing loss that was accepted by the insurance company without going to litigation. In fact, I had a hearing last week with Prince George's County police officer in which their own doctor stated that it was related to his 20 years of noise exposure, and I still had a full-blown hearing for the Workers' Comp Commission. So I'd ask for a favorable ruling to add the 4,000 hertz, and I didn't speak to the tinnitus, but I believe that that is a true issue that my firefighters and police officers are dealing with.
Good afternoon. Matt Pavel again with the Maryland Association of Justice, but I'm also going to speak to you as a member of the lawyer, rather, for the board of directors of the Middle River Volunteer Firefighters and Rescue Company, whose membership this would benefit. Pro bono position, by the way. I'm happy to serve in that position, but I'm going to limit it to the tinnitus, sometimes called tinnitus, the tinnitus portion of this, and with the story of Captain Dave Miller. Captain Miller drove for many years, and then for many years after that, as he rose through the ranks, he sat shotgun in the cab. And Miller describes a very, very noisy environment that just can't be avoided. First of all, obviously the siren that we all hear is it's as loud in the cab as it is for you and I in our cars. They honk that horn sometimes when they're not using the siren, sometimes together. Again, you've heard that honk yourself. It's a good thing it's loud because you get out of the way, but they hear that. Then, as if to make matters worse, they have a radio that they're listening to directions from headquarters as to the fire, what's developing, where they need to go, and so forth and so on. So they have to crank that up really loud so it overcomes those other sounds I've described. And if that's not enough, they have to shout to each other just to hear each other. So 32 years of doing that, after 16 years of doing that, Captain Miller developed tinnitus, and he couldn't get the treatment because he didn't have the hearing level needed. When he finally, the decibels for hearing loss, when he finally did qualify in year 30, he got the hearing aids that cured his tinnitus, but for 15 years, he dealt with that horrible sound in his ears. This bill would cure Captain Miller's situation. Thank you so much, Madam Chair, for this opportunity to testify.
Madam Chair, Jim McAllister from the MAJ. I live and I learn. Me too. Thank you.
Thank you, Jim. I'm going to follow my own rules. I have a question for Dr. Behringer.
Yes.
So it's sort of two edges, but how do you know someone's hearing loss is work related and not just age related?
In the vast majority of cases, tinnitus is related to hearing loss. It doesn't have to be, as you mentioned, especially a ratable hearing loss, depending on if it's higher in frequency than, what's accounted for via the formula. There are ways that we do in the office of we will pitch match the tinnitus. They will, report you'll play tones on the hearing test audiometer and see if they match it. We can see how loud sounds needs to be in order to cover it up. Also, because it is somewhat of a subjective, phenomena, we use surveys. One of the most common ones and the ones recommended by the AMA is what's called the Tinnitus Handicapped Index, where they will actually have different situations. We'll say, does it disturb your sleep? Does it disturb your ability to hear other sounds?
Answer my question. How do you know that it's work-related and not age-related?
Usually what you do is you compare it to the hearing loss to see, does it line up with the thing? You can also look at and how they do it through the VAs. They look at the medical records and they'll see like at what point they began reporting the tinnitus in relation to, like where they were they on unemployment, that sort of thing. So it's comparing the history of their occupation with the, when the onset of the tinnitus was.
Thank you. Go ahead. Any other questions for this panel? Thank you very much for your time. Jim Lanier, you're favorable with amendment. You want to come up? Are you going to be James this time or Jim? Because if I call you Jim, you say James. If I call you James, you say Jim. So I
call him OJ, other Jim.
The only person that calls me James is my mother when I'm in trouble. So it's favorable in the amendment if I may. So Jim Lanier on behalf of the Maryland Association for Justice, Your Honor, Senator. So the amendments are as the Senator Klausmeier already provided. There's no additional amendments, but I always get a little nervous when I'm signing up and it's like, well, it is an amended now bill. So should I say with amendments? So it's with the amendments that currently are. Beyond that, I have only one thing to point out, which is when we did present the bill at Economic Matters, some of the delegates were concerned about whether this bill expanded the amount of people or workers who could file hearing loss claims and tinnitus claims. It does not. If you could file a hearing loss claim now, you could file a hearing loss claim with your employer with this bill. So either way, it doesn't expand if this law does pass. It will not expand those who can file claims. It's just about the calculations more than the pool of potential workers who could seek benefits. And with that, the MAJ does request a favorable report. Thank you.
Thank you. Do I have any questions for this witness? Thank you very much. We have 4 unfavorables. So Carmine D'Alessandro, Ashley Smith, Michael Daly, and Brianna January.
Madam Chair, Madam Vice Chair, members of the committee, again, my name is Carmine D'Alessandro, representing Chesapeake Employers Insurance Company and Injured Workers Insurance Fund. In respectful opposition to Senate Bill 843, I certainly would like to thank Senator Klausmeier, Mr. Buttle, Mr. Darby, and Mr. Berman for attempting to work this bill out over the interim. We had it last year. We've tried. Apparently, we have failed. The hearing loss statute, like the workers' compensation statute, is built upon a compromise. The legislature allows occupational hearing loss, but the legislature baked in a formula to remove age-related hearing loss from that equation. So the legislature giveth, the legislature taketh away. When the legislature first amended this statute in 2002, it added 3,000 hertz for injured workers. It raised the age penalty from 40 to 50 for injured workers, but it also increased the level for hearing loss, for compensable hearing loss, from 15 decibels to 25 decibels. The legislature giveth, the legislature taketh away to keep that compromise in check. My concern with this bill is it giveth, and period. It erodes the age factor substantially. So the concern we have is adding 4,000, adding tinnitus, and allowing someone to keep working till 60, 65, but then not counting the fact that they're getting older removes that very delicate balance. I know I also floated a compromise that we would just raise the age penalty to 60 without any changes to the statute, just that would allow injured workers an extra 10 years of no penalty. I think it's safe to say that that was rejected. I don't want to speak for them, but I think it was rejected. So we are in respectful opposition because we feel that without the age implications, this bill does not really there's just not a rational basis for eliminating it to that extent. Thank you.
Thank you, Madam Chair. My name is Ashley Smith. I'm with the Maryland Defense Council. Something that wasn't brought up by the favorable proponents earlier that I wanted to emphasize to this committee is the way that tinnitus has been engrafted onto this bill. It's done in two ways. One, tinnitus is added onto a compensable hearing loss claim. It says, if you meet all these requirements and you have compensable hearing loss and you have tinnitus, you can get benefits for both of those at the same time. That aspect of the bill is really not that objectionable. As we heard from the audiologists, tinnitus usually goes hand in hand with hearing loss. The aspect of this bill that is most troubling is that it purports to allow tinnitus to stand on its own as its own claim. The reason that's troubling is that tinnitus is a purely subjective complaint. We really have no way of measuring it. And because of that, there's no date of disability that we can tie to it to determine when that tinnitus claim becomes ripe, when it is compensable, when statute of limitations runs. It basically is going to create a very large can of worms due to the subjective component and the inability to assign a specific day of disability to go with that claim. For that reason, we would encourage that that aspect of the bill where tinnitus is permitted to stand alone be stricken entirely, as that is just more problems than I think the bill was looking to create. And with that, I will just say that I am in complete agreement with Mr. D'Alessandro regarding the need for compromise, and that if we are going to go up to 4,000 hertz, we should also increase the level of compensability for the threshold. Thank you, Your Honor.
Thank you, Madam Chair. Michael Daly, on behalf of the Maryland Defense Council. Two things that I wanted to briefly touch on. First of all, just the reality in practicing before the commission is that the commission frequently in its permanency awards in hearing loss cases does award a percentage of disability for tinnitus. You heard the doctor reference the fact that the AMA provides a 5% disability related to tinnitus. Although it's not objectively measurable, the commission does award that based upon the totality of the medical evidence and testimony provided. So that is already compensated for. And there's no need for a separate tinnitus compensability component. In addition to that, the issue of hearing loss by statute is well established and well thought out as it exists today, that it's apportioned among potential exposure employers and insurers. Firefighters especially, we see frequently where they are a paid volunteer, and then they also volunteer 1, 2, 3 different houses. So the statute says if a firefighter, for example, is exposed over a period of time to a variety of different exposures in that scenario, then that hearing loss should be apportioned among those employers and insurers. And therefore, the issue as to whether or not you have to litigate that, as it was mentioned by one of the proponents, is it is frequently litigated to determine who is the proper employer and insurer in that scenario. And this bill certainly wouldn't change that. For all of these reasons, as well as what my colleagues had indicated, we'd ask for an unfavorable report. Thank you so much.
Madam Chair, Committee, still Brianna January with Mako, this time in respectful opposition to SB 843. Committee, my colleagues have done a good job of explaining our concerns with the bill. I'll just echo that we share the same concerns as the chair's line of questioning around natural age-based hearing loss versus work-related injury. With that, we encourage an unfavorable report on the bill, and we look forward to working with the committee. Thank you.
I'm going to ask this question to one person. You can choose who answers. You have to admit that firefighters have an unusual exposure to noise. Should this be a bill like a presumption for firefighters versus opening it to every occupation? Ashley, I can see you're thinking. Ashley.
I think the idea of the hearing loss statute is that it's intended to compensate individuals who are exposed to high levels of noise in general. Now, the vast majority of all hearing loss claims that I've ever handled in my 15 years of doing comp have been from public safety employees like paramedics, firefighters, and whatnot. But I don't believe it would be appropriate to exclude those workers who are also exposed in factories, construction sites, and other places who have similar experiences, though maybe not as unique, given the general breadth and intention of the act.
But this bill is an expansion for hearing.
Yes.
I'm just talking about this bill. Should the expansion be for public safety or should it be an expansion for everyone? Just think about it.
Am I thinking or am I thinking or am I answering?
You can get back to me.
Okay.
I'm really concerned about our public safety employees.
I understand.
I've ridden in a fire truck and with the siren and the horn, and it's really loud. And I think they have different issues than the average occupation. I might be wrong, but thank you. Thank you for your testimony.
Thank you.
Chair Quinn is here for information, so.
Good afternoon, Madam Chair, Madam Vice Chair. I'm Maureen Quinn, the Chair of the Commission. As you know, the Commission doesn't take positions on bills unless they affect us operationally. And this bill fits that criteria. So I must speak up on behalf of our commissioners because we don't know how to apply this law unless you add a section that amends 9-627. Under current law, an injured worker gets two pots of money, one for hearing loss, which pays up to 250 weeks, and a pot of money for their tinnitus, which pays up to 500 weeks. Section E of this bill says that tinnitus shall now be considered part of a covered employee's hearing loss. So we don't know whether the legislature intends to reduce both of those disabilities to an award of up to 250 weeks, or whether you intend to keep the two separate pots of money continually separated under this new law. So I did send something to the committee about this problem, but I just wanted to take a moment to explain to you in my own words what the problem is. It's about the money.
It's always about the money, Chair Quinn. Do I have any questions we may be getting back to you, Madam Chair. Thank you. Thank you for your comments. I don't see any other witnesses for Senate Bill 843. We're now going to go to Senate Bill 844, and guess who the sponsor is? Senator Klausmeyer. Yes, and her panel is Jeffrey Buttle, Matt Darby, and Kenneth Berman.
Senate Bill 844, Workers' Compensation, Occupational Disease, Presumptions, Hypertension. Thank you, Chair Bidle and fellow members of the Great Senate Finance Committee for the opportunity to present Senate Bill 844. This bill will repeal the requirement that certain firefighters and other specified related fields experience partial or total disability or death in order for hypertension to be presumed to be an occupational disease that was suffered in the line of duty and is compensable under workers' compensation law. Currently, hypertension is recognized in statute as an occupational disease presumption under 9-503 of the Labor and Employment article. Senate Bill 844 would amend this section to remove the requirement for the disablement, which under prevailing case law is generally considered 3 or 4 more lost days from work. Currently, the Workers' Compensation Commission has been denying hypertension claims when an employee's hypertension can be managed with medication. However, the employee may still develop complications from hypertension at a later date. When these claims are denied, the Workers' Compensation Commission is essentially disregarding the stated intent of the General Assembly that hypertension be presumed as an occupational condition. Senate Bill 844 simply makes clear that our firefighters and other specified public safety employees deserve the presumption so they can get the care that they need. I also want to let the committee know I'm requesting an amendment to establish that an individual meets the disablement requirement only if they have been on hypertension medication for at least 90 days. Thank you for your time, and I look forward to the discussion on Senate Bill 844.
Jeff?
Afternoon again, Madam Chair. Jeff Buttle on behalf of the Professional Firefighters of Maryland. We're here in support of this legislation. I will start. We're currently trying to work with the amendments office on getting some language to the concept that the senator spoke about. So conceptually, we're in support of that, and we'll get the language straightened out so the amendment can be presented to the committee. Last year, there were some members that were thought that we were seeking a new presumption for hypertension. That's actually not the case. This is one of the original presumptions that was originally put into law, and we actually went back because I was curious as to when these were first established under Maryland law, and it was actually in 1971. It's how long the hypertension presumption has been around, but we really do need to address the issue of what constitutes disablement on the hypertension presumption. I know you will likely hear from the opposition that they do not like the way the bill is currently written. I think the amendment that the sponsor is working on perhaps would address that, but we really do need to tackle the issue. So I don't want to get too hung up on the language as the bill was introduced, but we really need to work with the committee, and we're hoping to be able to work with the committee on finding a solution to this problem so we can resolve it and move on. Thank you.
Mr. Darby?
Yes, still Matt Darby, and I've been practicing law representing firefighters about 15 minutes longer than the last time I was here. This obviously hypertension is a condition that whatever we can do to help firefighters maintain control over it is very important. It can lead to so many other things. It can lead to end-stage kidney disease, other issues with the body, and so whatever we can do to promote and allow access to the benefits of the workers' compensation law in this regard, I think is important. What we struggle with as a practitioners is that really the idea of what is disablement and what triggers an occupational disease for hypertension is really all over the board. It varies really from commissioner to commissioner. This gives everyone a bright line. Whatever that trigger may be, we need that bright line. It's going to help reduce the number of hearings on the issue. And it's going to help reduce the number of appeals, and it's going to promote us as attorneys to know when a claim should be filed. And so what we urge a favorable report to give us that tool to help firefighters maintain their good health on this issue. Thank you.
Afternoon. Last year, when we were here, the opposition to this bill was that there was no objective definition. Senator Kramer, as you're leaving for 1 second, if I can refresh your recollection. Last year, Senator Kramer told our worthy opposition, go to lunch, go to dinner, and work it out. So what we did is we came back with a revised bill which had the objective standard. Only will keep you for 30 seconds. We came back with an objective standard, which was 3 high blood pressure readings sequentially, so it would not just be a transitory issue of when you see the doctor and you have white coat syndrome. Well, 2 weeks ago, they told us they don't like that. So we've now come up with fine that you're on medication for at least 90 days. If they don't like that, then I'm getting the suspicion that they're not going to like a whole lot, and they just may not want anything to be done. But we've done in terms of what you've requested, which is to go out and come up with various objective standards for that somebody can tell whether or not they really do have hypertension and have a disablement. Thank you for your time. Won't keep you any longer.
Thank you. That ends this panel. Next we have Jim Lanier, John Hall, and Matt Cavola.
James Lanier on behalf of the Maryland Association for Justice. We're just here to say me too.
And Matt Pavla, also with the Maryland Association of Justice, also going to say me too, but I do want to mention again that I also represent as attorney the Middle River Volunteer Fire and Rescue Squad, who of course favors this. Thank you so much.
Thank you.
Good afternoon again. My name is John Hall. As I stated before, I represent firefighters and police officers. I probably do as many or more hypertension claims as anyone that's practicing at this time with public safety. I just wanted to point out a few things that are practical in nature. Before the Economic Matters Committee, our opponents testified that they accept all these cases are accepted, that disablement doesn't mean you have to miss work. Well, I spoke to Chairwoman Quinn this morning before the hearing, and we spoke about this exact issue. That is completely inaccurate. A firefighter must miss 1 day minimum, up to 3 by some of the other commissioners. So when you hear from our opponents that they don't have to miss work, that is not true. Additionally, I've had hearings where my physician keeps a firefighter out of work for a 140/90 blood pressure reading. The NFPA, if a firefighter is 140/90, they're not allowed to ride a truck. They're not allowed to perform their duties as a firefighter. Yet I've had the commission, because they say, some of the commissioners say there's no disablement at 140/90, even if they miss time, it's a problem. So I'm here to testify practically that, first of all, these claims aren't accepted. I try every one of mine. And I can tell you also, they'll state that, well, if it's not ripe, they can come back later and file their claim when there is disablement. Well, that disablement might be a stroke or a heart attack because they haven't been properly cared for and treated. So please pay attention to our opposition and note that you do have to miss time from work as a standard by the current Workers' Comp Commission.
Thank you, Mr. Hall. That ends this panel. I don't see any questions. Next, we have the unfavorable panel. This is like, getting to be routine. Carmine D'Alessandro, Julie Murray, Ashley Smith, and Michael Daly.
Good afternoon, once again, Madam Chair, Madam Vice Chair, members of the committee. Carmine D'Alessandro for Chesapeake Employers Insurance Company and the Injured Workers Insurance Fund, here to respectfully oppose Senate Bill 844. Mr. Berman is correct. The 3 tests that were in the bill, which I believe now have been removed, we did take issue with. I have not seen the amendment. I can say it certainly is an improvement over the 3 tests, and is something that I will have to consider. Mr. Berman was kind of to tell you that outside. I can't speak to all Mr. Hall's cases. In the last 190 hypertension claims that Chesapeake or IWIF has had, only 8 have been denied, 4%. And with all due respect, there is not, I think the reason everyone is here is there is no definition of disablement. I understand certain commissioners may feel different ways, but there is nothing in case law or statute that defines it. So for example, you don't have to miss work to be disabled. You could be working at the Safeway market, have carpal tunnel, and not be able to work on aisle 10 with all the bulk stuff and be sent down to aisle 1 in the express. Your job has changed. That could be disablement. So there is no definition, hence the bill where they're trying to come up with a definition. Again, I haven't reviewed the amendment to think about all the downstream things that could happen, but in listening to the testimony, I was thinking of your last question in the last hearings, as I was directed to do. We've now had 3 bills, post-traumatic stress presumption, the question of whether there should be a presumption for firefighters in the hearing loss situation, and now really a presumption within a presumption, presuming that disablement is 90 days of medication within the hypertension presumption. I don't know how to go about doing this, but I think in answer to your question, I'd like to expand upon that summer study and put on the table the issue of presumptions in general. And I guess I will send my request to the appropriate individuals.
Thank you, Mr. D'Alessandro. I'll look forward to it.
Thank you, Madam Chair, Vice Chair and the committee. My name is Ashley Smith. I'm speaking on behalf of Maryland Defense Council. I just wanted to emphasize for the members of the committee, the Workers' Compensation Act is not a general health care bill. It exists to compensate our injured workers, especially our first responders, when they encounter a disabling condition. This bill does not exist to provide mere health care. The state, the municipalities, the counties, they all provide health insurance to their firefighters. The only reason that that hypertension should be coming before the commission are in instances where a disablement has occurred. And that is where the condition has progressed to the point where that has necessitated them to miss time from work or to incur, as Mr. D'Alessandro indicated, some change in their occupational duties. And this is baked into the substance and the intent of the Workers' Compensation Act. The whole idea of occupational diseases is that they can exist for many years and progress slowly over time, and they do not become compensable until they affect your work and cause you to miss time from work. Removing this disablement requirement from the hypertension statute is truly a slippery slope and begins transforming the COMP Act into a health insurance act. And we would, for those reasons, respectfully request an unfavorable report.
Good afternoon again. Julie Murray, co-chair of the Workers' Compensation Committee for the Maryland Defense Council. I am here today to also ask for an unfavorable report and to point out just 2 points that I think were brought up in support of the bill and have been brought up in the past. If one of the 8 claims that Mr. D'Alessandro mentioned is denied for hypertension due to a lack of disablement, that does not mean that the person has lost their claim forever. A lack of disablement finding is a finding essentially that the claim is not ripe. And that's an important distinction because some of what has been lost in translation is that if a person is not yet at the point in their occupational disease where it has become disabling enough to meet that requirement, all that means is that they wait until they hit that point and then they come back. We have heard that people have general health insurance through their municipality or their employer, so they can still receive the treatment when their occupational disease progresses to the point where they have disablement as defined by our commission, by our courts. They can then pursue their claim again when they have that disablement. We do have concerns that defining disablement in such a limited scenario in this bill as it pertains only to firefighters and only to hypertension creates possible ramifications that could seep into other areas, other occupational diseases, other presumptions, and other safety personnel that are perhaps not intended to be covered in that fashion. And for those reasons, we would respectfully ask for an unfavorable report.
Good afternoon, Madam Chair, members of the committee. Michael Daly on behalf of the Maryland Defense Council. Very briefly, for me, I think what is very revealing is the data that Chesapeake and the Injured Workers Insurance Fund on behalf of the state provides, as Mr. D'Alessandro pointed out, specifically shows that the majority of the hypertension cases are in fact accepted and paid. This bill, however, does not change the fact that there are certain limited number of these cases that will always be litigated, even if this bill would somehow pass in some version. And what I mean by that is there's a legal concept called last injurious exposure. The issue of whether or not somebody's exposure within their field of public safety that they're involved is in fact the last injury exposure they had that would created the presumed hypertension occupationally induced. So this bill would not change that in any way. Cases that need to be litigated to determine that and have a commissioner determine who would be responsible for the claim would still be litigated in that event. For those reasons and those as my colleagues have already stated, we'd ask for an unfavorable report. Thank you so much.
Thank you to this panel. I see no questions. That ends the hearing on Senate Bill 844. Senator Glassmeyer, you now have Senate Bill 845, and your panel is Deborah Fraser Smith. And I would just like to say. Microphone closer, please. Thank you. Okay. Senate Bill 845, Workers' Compensation, Temporary Partial Disability, Concurrent Employment. Thank you, Chair Vital and fellow members of the great Senate Finance Committee for the opportunity to present Senate Bill 845, which aims to update Maryland's workers' compensation statute to better account for the increasingly common scenario of a claimant with multiple jobs who sustains a work-related injury. Many households currently require the breadwinner to work at least 2 jobs to make ends meet. To account for this, some other states have incorporated the second job wages into calculation of average weekly wages when a worker gets injured on the job. I want to be clear that this bill does not take this approach. Senate Bill 845 will provide a small carve-out that will provide that a claimant is entitled to temporary total disability benefits only in certain circumstances. Under the bill, the claimant can only receive benefits at the time of the total rate if the claimant has a second job at the time of the injury on the first job and is determined to be physically able to continue working the second job. This prevents the employee from having to choose between keeping the second job and receiving any benefits from the job in which they were injured. This will not only protect the claimant from being left behind when they are injured, but will also help Maryland's economy by keeping Marylanders working. I am accompanied on my sponsor panel by Deborah Fraser Smith, who is a workers' compensation attorney and can explain in more detail how this legislation would work in practice. And I want to thank the committee for their time, and I look forward to the discussion on the Senate Bill 845. And Deborah is a member of the Workers' Comp, as well as some of the other folks have been there, members of the Workers' Comp Oversight Committee. And she contacted me, so. Okay.
Thank you, Madam Vice Chair, Madam Chair and members. It is lovely to be here today on the other side of the table. As Senator Klausmeyer says, I've served almost 20 years on the Senate House Joint Oversight Committee. I've been practicing law coming up on my 40th year, but we don't have to talk about that. Concurrent employment and workers' comp. This is a very critical issue, but it's very easily fixed. I appreciate the opportunity to speak on behalf of this bill, which is the first time it's being introduced. As the senator alluded to, many might not know, but compared to the DMV, Maryland is really behind. Most of the states, including the District of Columbia, allow the employees to stack all of their employment at the time of the accident in order to reflect a total average weekly wage. Maryland does not. But I respect that. This bill would not change our structure, our case law, or definitions. I believe both the claimant and defense attorneys need to keep the ship steady, no radical changes, and my colleagues know that. However, we have had in the past small improvements or adjustments for purposes of the public good. We have such an opportunity, ladies and gentlemen, today. The governor has stated that Maryland is now lacking workers for many positions in Maryland. And households are having a tough time making ends meet and holding down 2 jobs, not because they want to, but because they have to. So this bill is for the employers and employees alike. Simply, it allows for the worker to keep his or her part-time job if physically able, which is one of the requirements, and for a temporary period of time while receiving those benefits that the employer would have to pay out anyway during his or her disability from the job that they were injured.
Thank you. Do I have any questions from this panel?
May I ask a question from here since I'm not up there?
Yes, Senator.
No, could you give just briefly an example of two different kind of jobs, whether one is very manual and one is office wise or whatever?
Thank you, Senator. Absolutely. Let's give the example of perhaps a mechanic who works for county government. That's his main job or her main job, and they get very seriously injured to the point where they can't do the mechanic job. But for a couple years now, that person has been working on weekends to make ends meet as a security guard. And quite frankly, the doctor says he can absolutely do that. He can sit at a desk until he's better and can return as a mechanic. So under current law, he's going to be fired from that job that he's had for many years because he's torn. He has to pick. Does he receive his benefits or does he keep this part-time job and lose his house or not be able to put groceries on the table? This is literally the situation. I have several clients this month with this exact situation. They have to pick. So are we helping the employer who is losing a faithful employee he's had for 2 years? He has to let him go because he got hurt on another job, but he can do his job. Does that help the economy? Does that help the state of Maryland? I suggest not. And so what happens is that in this bill, and again, this is not someone that gets hurt and then says, oh, I can go work another job and you still have to pay me. This person has the history. And I think we put in the bill 8 weeks. You have to show demonstrated payroll. He's already had a history of a good work record with this part-time job, or he does a part-time gig with Uber or whatever he does to make ends meet. And then secondly, you have to have a physician who says, look, he can sit behind a desk, but he can't do mechanics work yet. And then third, we want to cap it out. So this is just a temporary ladder, so to speak, to help the employer to keep his workforce and an employee to be able to manage his family. And it's just temporary. So that's a good
Right.
example.
Yep. Thank you. Thank you.
Thank you. There are no other questions. We have 2 more people favorable, James Lanier and James McAllister, and then 4 favorable with amendment, Calvin Morris, if you'll come to the table.
Good afternoon, James Lanier on behalf of the Maryland Association for Justice. So temporary partial disability, the framework for this bill is that the entire reason for the comp system is to get people better and back to work. Temp partial is generally a bad deal for the injured worker. So in addition to what Ms. Fraser-Smith said, it's important I'm going to talk about math speaking about it, so it's very difficult, but the math doesn't work for temp partial. Let's say that mechanic's job that Ms. Fraser-Smith mentioned is $1,000 a week and they make $300 as a security guard. Their earnings for that week is $1,300. Now we only count the injured worker's job with the work injury. And so they would only get $667, even though they're not working either one of those jobs, because you can't work any job to get temporary total disability. So let's say they go back and do that part-time job at $300 an hour. That means that the total amount they would get with the wages and the reduced benefit from the injured worker job is $650. So by going back to work and getting the same wages at the part-time job, they actually end up getting less than if they would have just stayed out of work totally. Well, that's not the point of workers' comp. The point of comp is to get you back to work. But then you have to have the conversation with the client. There's law and then there's reality. The law is that you can go back to work and you can ultimately get less money, or the reality is you can not do that extra job because financially you're going to do better off. Well, that's not what we're focused on. We're focused on trying to keep people back to work. We want to encourage them to go back to all of their employment. But when there's a financial detriment to the injured worker to return back to any of the employment, then you lead to where the fiscal note comes in, where they're talking about how there's going to be an increased benefit of the injured worker and the insurance company for the at fault, excuse me, not at fault, for the employer at the time of the injury. The problem is that if that worker doesn't go back to that part-time job, they're still paying that 667 in my little example. So it doesn't change the amount of requirement if with this, because they're going to have to pay it because that person's not going to go back to the part-time job. So we're asking for a favorable report.
Good afternoon. My name is Jim McAllister. I'm a member of the Maryland Association for Justice. This is a pretty simple concept, but it requires understanding a little bit of workers, what my client called workers' complication speak. So there's something called temporary total disability. And the best way to think of that is lost wages. You're paid 2/3 of your average weekly wage. They average together the 14 weeks before you got hurt. And they figure out that that's what you're averaging. You're paid 2/3 because it's tax-free. So the way that works is, as long as you're not working, you're entitled to 2/3 of your average weekly wage. Now, for the 2-income household, and I've yet to meet somebody who went to work on the day they got injured, expecting to get injured, all of their bills, if they're a 2-job employee, are based on 2 incomes. They're driving Uber, they're driving Lyft, they're working in a restaurant part-time. They're doing 2 jobs to make ends meet. And so they get hurt on one job and they can't do that. And usually that's unfortunately the higher paying one. So they're working this part-time job to keep going, but now they get substantially less money. So their bills, their mortgage, their insurance payments, all of which were geared on they were going to be making 2 incomes, are now not being paid because they're getting less money than they would get had they been going to work. If workers' comp's job is to get people to survive, this is a great bill because it keeps your purchasing ability the same. And also it's for, one of the things I love about this bill is it's for a limited period of time. I think it's for 6 months. And after that, if you can't get your 2-income household together in 6 months, then move to another job, or maybe there's a more serious problem here. But for that temporary time, when you have the panic of how am I going to make ends meet with less money, substantially less money than I'm used to, this is the perfect salve for these people and their families. Thank you. We urge favorable.
Not right now, not until questions pending. And then we have one favorable with amendments. Is he up there? Is that Calvin Morris? Okay, can you, slide over the microphone right over to you? Okay, you can go ahead.
Great. Thank you. My name is Calvin Morris. I have been employed for 8 years at 2 jobs. June 17th of last year, I was injured at my second job and am currently for just shy of 9 months, unable to work both of my jobs due to the injury sustained at my part-time job. I was bringing home after taxes, working both jobs over 60 hours a week, 7 days, $850 about after taxes. Due to the fact that I was injured at my part-time job, workers' compensation is only required to pay me 2/3 of the salary gained at that job, meaning I am currently being expected to survive on $137 a week provided by workers' compensation because they are going off of my second income, which was a part-time income. So all of that inability to survive on $137 a week, because I don't know anyone who can, I have had to go then and apply for state benefits in the energy assistance and food stamps. So the fact that the insurance company has gotten away with paying me $137 a week instead of the $550 a week they should be paying me based on both my salaries, I have been turned over to get support from the state. So the state has had to put out energy assistance and food stamps in the amount of $4,000 because the insurance company got away with $14,000 that they should have had to pay me based on both my incomes. So I would like it taken care of, and the 6-month time frame, I'm just shy of 9 months and I'm still nowhere. And why does this bill have to wait until October when I've already showed you how much money it costs on a weekly basis? Why put it off that much longer? Thank you.
All right, thank you, Mr. Morris. Do we have any questions for this panel? All right, thank you very much. We have next up The unfavorables, Carmine D'Alessandro, Julie Murray, Ashley Smith, Michael Daly, Angelica Bailey Tupari, and Brianna January.
Thank you, Madam Chair, members of the committee. Once again, Carmine D'Alessandro, representing Chesapeake Employers Insurance Company, Injured Workers Insurance Fund. I believe the panel will be discussing case law and the current statute. I'd like to talk about the effect that SB 845 would have on insurance rates, and for those reasons would respectfully oppose SB 845. The major tenets of insurance rates are they cannot be arbitrary and they must be responsive. On the first, the arbitrary, Chesapeake insures 19,000 policyholders, employers. We basically totaling $6 billion in payroll. We have no idea how many of those individuals have secondary employment. So when we factor in insurance rates for all those insureds, we have no idea that there could be additional liability out there. If this bill were to pass, rates would be arbitrary because they would become random based on finding those facts out after the fact. Lastly, rates must be responsive, meaning they must respond to what the employer caused. If you're a restaurant owner and you have an employee who is injured and can no longer work at the restaurant for 3 months, but can work his or her second job, under this bill, you are paying for someone who is totally disabled, even though your employment only caused that partial disability. Your insurance rates are then based on payments for someone who is totally disabled, even though your employment only caused the partial disability. So your rates would be inflated. They would not be responsive to the actual injury that was caused on your watch. So for that reason, and the reasons that I'm sure are coming, Chesapeake and I would respectfully oppose Senate Bill 845. Thank you.
Good afternoon again, Julie Murray on behalf of Maryland Defense Council. I am here to just briefly speak and give you some context for some of the numbers and figures that you were given and have been submitted to you about what is paid in temporary total versus what is paid in temporary partial, and the allegations of wage loss that we've heard from the proponents of this bill. And really my comment is very brief, just to give you that context, which is that you should be aware that when you're hearing about a wage loss, something to be aware of is that workers' compensation benefits are non-taxable. So a person that is receiving, the reason why our statute is framed in such a way as to give an injured worker 2/3 of what they were earning before is because that is designed to replicate the take-home pay that they would be receiving because workers' compensation benefits are non-taxable. The other members of the panel have more to say on some of the nuances of the bill, but we just wanted to make sure that the committee had that information and was aware of that when you are considering the bill. For all of the reasons that everyone else is going to discuss, MDC would urge an unfavorable report on this bill.
Hello, I'm Ashley Smith on behalf of the Maryland Defense Council. I'm going to be very brief and just point out this bill as written creates a potential for double dipping. You stop being able to work your primary job where the injury occurred, and you go from working part-time in your second job to now working full-time in your second job, and suddenly you're making twice what you were making before you were injured. That is a potential pitfall with the language of this bill. I would also point out that the language of the bill as drafted is a bit vague, as it doesn't make it clear how this bill would apply to an injured worker who is working a light duty position in the original employment for the employer he was injured with. So I'm working as a steel worker in a steel line. I get injured, I get assigned to light duty in the steel mill, but I'm doing something sedentary. I'm sorting receipts, I'm doing filing, something else, but I'm making something different. The way this bill is drafted, it's unclear. Does that mean that you still get your temporary total rate, or would you be paid temporary partial as normal? I just, unfortunately, the way that this is written, the way it's drafted, I see a lot of potential for abuse. Not only just due to vagueness, but also for potential double dipping. And we wanted the committee to be aware of that. And for that, we would ask for an unfavorable opinion.
Good afternoon, members of the committee. Angelica Bailey Thupari for the Maryland Municipal League. I would refer you to our written testimony as well as the fiscal note. I'm not going to pretend to be an absolute expert on workers' comp like our colleagues here at Chesapeake, but if something's going to increase costs and inconsistency for Chesapeake, it will have the same impact on local governments. We heard earlier about the public good, and that's exactly what local governments are trying to accomplish. Anything that creates inconsistency or increased expense for us will make that more difficult. Thank you.
Madam Chair, Committee, Brianna January with Mako in respectful opposition to SB 845. I will simply add a me too to all of my colleagues and their concerns around the bill. We urge an unfavorable report. Thank you.
Madam Chair, apologize for going out of order there. I was sitting back. I'm Michael Daly on behalf of the Maryland Defense Council. The primary concern that has not been mentioned yet that the MDC has is the wording. We believe the statute does a very good job. The legislature has done an amazing job of creating a fine working machine statutorily. This bill convolutes the concept of what we refer to within the practice as temporary total disability versus temporary partial disability. Yet this bill says if somebody is temporarily and totally disabled from their work injury, but can work a secondary employment, the reference to temporary partial in this bill is inconsistent. And quite honestly, I'm not sure how the commission would be able to apply that. Because it talks about a medical doctor saying somebody is temporarily partially disabled. Well, if they're unable to work the job in which they were injured, they're temporarily and totally disabled as a matter of law by our act. So the concept of then saying they're temporary partial simply does not make sense. And honestly, I don't think it would be something that could easily be applied by the commission. It's inconsistent with our current statutory framework. The other concern we have, our members represent businesses of all different sizes, and the fact that the fiscal note details the fact that for small businesses, it's a potentially meaningful financial impact is concerning. As you all know, we're a premium pursuant to audit state. A small business, mom and pop, gets a premium estimate, and all of a sudden they're hit post audit because of the secondary employment nobody knew anything about, and they're unable to pay that. So for all of those reasons, we'd ask for an unfavorable report. Thank you.
All right, thank you very much. Are there any questions for this panel? All right, thank you very much. That will conclude the hearing on Senate Bill 845. Senator Klossmeyer up again with Senate Bill 919. And it appears on the of your panel is Jim Lanier, Matt Pavola, and James McAllister. Senate Bill.
Senate Bill 931, Workers' Compensation Rehabilitation Practitioners License. Okay. Oh, do I have the wrong bill? 931?
Senate Bill 919, Senator. I've got Workers' Compensation Modification of Award Extension.
Wait a minute. Got all my paper, my things here. Okay, I'm sorry. I threw that underneath there.
It's okay.
So that means we have two more to go.
A lot of this.
Workers' Compensation Modification of Award Extension. Senate Bill 919 is narrowly tailored to address a problem that does not occur often, but when it does, can be detrimental to the injured worker. This bill is designed to briefly extend the time period in which the Maryland Workers' Compensation Commission maintains jurisdiction over modifying certain awards if the original time period for requesting a modification lapsed while a claim is on appeal. A worker may request a modification to a prior commission award as long as the request is made within 5 years after the date of the accident, the date of disembowelment of the last compensation payment, However, the commission does not have the jurisdiction to decide modifications of prior awards while a claim is on appeal. Senate Bill 19, with the sponsor amendment I have offered, will extend the amount of time for an injured worker to request a modification with the commission by 60 days when the time to file an application for modification of an award lapses after the appeal is filed, but before final resolutions of the appeal. The 60-day extension allows the claimant additional time to request a modification when the 5 years runs out while an appeal was pending and the commission lacked the jurisdiction to decide if a modification should be granted. This extension of authority to the commission will contribute to decisions that will ensure the workers receive the proper consideration by the commission that is correct for their circumstances. This bill will also clear some of the commission's pending hearing dockets, since injured workers will no longer have to request hearings when the commission lacks a jurisdiction to resolve the dispute. In short, this bill will allow for modifying workers' compensation to be more effective and efficient process. Thank you, and I look forward to the discussions on Senate Bill 919.
Afternoon, James Lanier on behalf of the Maryland Association for Justice. So the original bill, there were two criticisms that I picked up on at Economic Matters, which was this doesn't happen very often, which is absolutely true. This is one of those where it happens infrequently, but when it does, it can have extreme negative impact on the injured worker and their ability to get out of work benefits or additional permanency benefits. The other criticism was, as drafted, the bill did not tie the 60 days specifically to being on appeal. So the amendment should solve that problem. So the inherent problem is when you have an indemnity benefit, benefits that go directly to the injured worker, you have 5 years from the last payment or the last date of accident or disablement to request a modification. Well, and I had a situation for a client who came back after a neck surgery 4 years after his last benefit, said, hey, I need a revision. We ended up trying that case. I ended up losing at the commission. We filed an appeal. Now the appeal's going on, but the 5-year clock kept going. Eventually, the employer insurers, doctors agreed my client needed the surgery. And I had to, and he eventually got the surgery and he's currently getting out of work benefits now. But I had to file a request for modification, even though the commission had no jurisdiction to decide that issue, just to keep your foot in the door. So every time the case came up for a hearing, we had to continue it, and we had to continue it, and we had to continue it until finally the appeal was resolved and that modification of a prior permanency could be decided by the commission because they now had jurisdiction again. So what this would do is, instead of me having, or a worker, a claimant's attorney having to file issues that cannot be resolved by the commission, it'll allow the 60 days when the 5 years runs out while the appeal is pending to simply ask for the modification at the commission, and then the commission has the same jurisdiction and the same abilities to either grant or deny the modification. We ask for a favorable finding.
Thank you, Matt Pavola, also with the Maryland Association of Justice. I'm just going to add to what Mr. Lanier said very briefly. I won't even take a minute of your time. The situation is that described as this is a simple bill. It's a simple fix to a problem, admittedly, that doesn't crop up often, but when it does, it's a very onerous situation for the injured worker. And it clogs up the commission docket unnecessarily with these, you heard Mr. Lanier describe in his case, that he had to keep going back down, just to keep the foot in the door and seeking these postponements. Won't have to do that anymore. While the matter's on appeal, everyone can rest and take a breath and not worry about the 5-year lapsing. Simple bill. We would urge, please, favorable treatment on Senate Bill 919.
Good afternoon, Madam Chair, members of the committee. My name is Jim McAllister. I'm a trial lawyer. So here's how the problem comes up. So there's basically the right to lifetime medical care. So between now and eternity, the injured worker has the right to causally related, reasonably necessary health care. But with regard to money, meaning money for lost wages while you're taking time off to get a surgery, permanent partial disability because your ability to earn income has been compromised by the fact that you've gotten worse, you have to go back to the commission and ask for that within the 5 years of the last payment of compensation. So the 5-year clock starts to run when your client gets the last check. 3.5 years later, they call me up and say, Jim, my back's killing me. My doctor says I need a surgery. I go to the commission and the commission says, because they buy the insurance company doctor no, and I say that's not with a K, who says, no, it's not related. And I wind up on appeal. Well, the circuit court, it takes about 1 year to 1.5 years to get that case tried. So while that case is pending, the commission lacks jurisdiction because I'm saying that my client needs more medical care. To increase my client's permanency award, I need my client to be at maximum medical improvement. So I'm saying one thing in the circuit court, my client's at maximum medical improvement, yet I'm saying at the commission, they're at maximum medical improvement within 5 years to protect the 5 years. I'm saying two contradictory things. I've seen commissioners say you can't say both. This prevents that problem. This says you can't run out the clock by filing an appeal. What if the employer files the appeal of the surgery issue? Now they've filed the appeal and it goes on for 1.5 years and the statute of limitations comes and goes. What if they appeal an MRI finding and that medical issue is up there pending, deprives the commission of jurisdiction? We need this to be clear. Statute of limitations is live or die. It needs to be crystal clear, and that's what this bill does. Thank you.
All right, thank you very much. Do we have any questions for this panel? All right, thank you. Up next, we have the unfavorables, Carmine D'Alessandro, Julie Murray, Andrew Griffin, Ashley Smith, Nancy Corson, and Michael Daly.
Thank you, Madam Chair, members of the committee. Once again, Carmine D'Alessandro for Chesapeake Employers Insurance Company and Injured Workers Insurance Fund. Thanking Senator Klausmeier for introducing this legislation, but respectfully opposing Senate Bill 919. And I just for the first time heard there was an amendment. The bill as written does not address the issue about your time running out while on appeal. It just simply adds 60 days, which means the same thing could happen under the language of the bill. I don't know what the amendment says, but with that, what I've heard was that this rarely happens, which is true. I've been doing this for 30 years and I've never seen it happen, so it rarely happens, once in a blue moon. But I've also heard that these issues are clogging up the docket. If it's happening once in a blue moon, it certainly is not clogging up the docket. As you heard, you simply file issues. You may have to ask for a postponement, but the filing of issues is going to protect your client. So this is only happening, even if it happens once a year. I don't think that legislation is needed to basically cure something that is not actually a problem. So for those reasons, I would respectfully oppose Senate Bill 919, excuse me.
Good afternoon again, Julie Murray on behalf of the Maryland Defense Council. Just to add a little context to what Mr. D'Alessandro had alluded to, MDC did poll our members in preparation for the hearings last week and this week because it is our belief that this is a very small, rarely occurring issue. We polled our membership and there was not a single person who had a case that they could recall in the last year where this arose. As a result, MDC simply believes that this is a solution in search of a problem. If this does come up on those very rare occasions on an off year, there is already a mechanism in place to preserve and protect that statute of limitations. Claimant can file issues. Those issues can be postponed until such time as the appeal is remanded. For that reasons, we don't believe the bill is necessary and MDC would respectfully oppose Senate Bill 919.
Thank you, Madam Chair. Excuse me, the members of the committee remaining. Andrew Griffin here on behalf of the Maryland Chamber of Commerce, respectfully in opposition to Senate Bill 919. I've asked Nancy Corson, who you mentioned, to come here at my request to answer questions you may have of the chamber. Respectfully, the bill is extending the timeline in which employers can be exposed to additional claims costs and the uncertainty of additional claims. And from the chamber's perspective, that is simply going to add to the cost of workers' compensation insurance in the state, add to the cost of operating a business in the state, which this committee hears me discuss time and time again is just not something the business community can deal with at this time. So I will conclude my testimony, urgent unfavorable report, and happy to answer questions. Thank you.
Thank you, members of the committee. My name is Ashley Smith. I'm just going to rest and say that I agree with everything raised by my colleagues up here.
Thank you, Madam Chair. Michael Daly, on behalf of the Maryland Defense Council. Me too.
Right, and then Nancy Corson, she doesn't have
Just
any
here for
testimony,
questions.
just here for questions. Okay.
Thank you.
Are there any questions for this panel? All right, seeing none, thank you so much. All right, and that concludes the bill hearing on Senate Bill 919. We'll now move on again to Senator Klossmeyer. I think the last of the Senator Klossmeyer bills for the day, and it's Senate Bill 931. Looks like Arthur Flax with your panel.
Title, Workers' Compensation Rehabilitation Practitioners, Licensed Social Workers. And this is number 931. Hi, here we are. Thank you, Chair Dial. And fellow members of the wonderful Senate Finance Committee for the opportunity to present Senate Bill 931. This legislation was first brought to this committee last year as a House bill without a cross file, which did not give us time needed to work on the bill. The legislation this year is more straightforward. With the sponsor amendment, I am introducing this bill only as licensed social workers into the section of the labor and employment article that defines rehabilitation practitioner. The bill further clarifies that a licensed certified social worker clinical, and that's considered a LCSW-C, may also be among the providers such as doctors and licensed psychologists who are permitted to perform evaluations as to the mental or behavioral issues that are being considered in a permanent impairment determination by the Workers' Compensation Commission. I am joined by my sponsor, Arthur Flax, who is a longtime practitioner of social work in Maryland, and he can explain more of the background.
Okay, Mr. Flax?
Yes, ma'am. I guess I only have 2 minutes.
Yeah, can you move the microphone over closer to you? Thank you.
First, I'd like to say that as a licensed certified social worker clinical, we do use the AMA guide to the evaluation of permanent impairment, the 14th chapter, mental and behavioral disorders. And we also use the DSM, Diagnostic and Statistical Manual of Mental Disorders, the International Classification of Diseases, and the Global Assessment of Functioning, and other assessment tools and diagnostic tools. We're also providers as licensed certified social worker clinical. We're a separate license from other social workers. I want to make that clear. And we have the authority under the law to for the evaluation, diagnosis, and treatment of biopsychosocial conditions, mental and emotional conditions and impairments, and behavioral health disorders, including substance abuse disorders, addictive disorders, and mental disorders, as defined in section 7.5101 of the Health General Article. So I want to make it, there was information presented last year and earlier at the House that was misleading to the delegates. So I want to make that clear. And also the AMA, the evaluation, the AMA guides to the evaluation of permanent impairment does not limit, chapter 14, mental and emotional disorders does not limit the evaluator to a physician or a psychologist. It says in there, psychiatrist, psychologist, or other trained rater. So those are the main points I want to make clear. We have an Attorney General's advice and counsel that supports us and so forth.
Thank you very much. Are there any questions for Senator Klossmeyer or Mr. Flex? Seeing none, thank you very much. All right. Next, we have up Jim Lanier, Matt Favolo, and Christine Crone. You come up.
Jim Lanier on behalf of the Maryland Association for Justice. Mr. Pavela had to step out, so with the permission, we would request Mr. McAllister be able to speak in his stead.
That's fine. Go
Okay,
ahead.
thank you. So the bill essentially does two things. My talking points were about the vocational rehabilitation side. However, there doesn't seem to be any opposition to that portion of the bill. So just very briefly, by adding a clinical social worker to the vocational rehabilitation process could expand the amount of people who are involved, especially with a mental health claim that is prohibiting the person to go back to their pre-injury job and helping that person to find suitable gainful employment. For that portion of the bill, we asked for a favorable report. And again, I don't believe there was any opposition to that at Economic Matters. For the permanency side, at the end, when the worker is basically better and back to work, we have to find out what, if any, permanent injury that they have or permanent impairment that they have. The reason this bill would be helpful to injured workers is, at the moment, there's essentially two people in the entire state who will do permanency evaluations for psychological injuries for injured workers, and both of them are in Baltimore County. So that this would expand the pool of potential people that you could utilize to be able to do those impairment reports for mental health injuries in compensable workers' compensation claims. We asked for a favorable report on this bill for both the vocational and the permanency impairment parts of the bill. Thank you.
Thank you.
All right,
Mr.
thank you.
McAllister.
Good afternoon, members of the committee. My name is Jim McAllister. I'm a trial lawyer. Let me explain how this comes up. So when you file for permanent partial disability, what you're saying is that my client is now a three-legged racehorse. And because workers' comp deals only with economic value, there's no compensation for pain and suffering. And the assumption is that somebody that has a permanent restriction going forward, we call that an impairment, as a result of an injury, is going to be less productive, is going to make less money than the four-legged thoroughbred that they used to be. And so we award them compensation for permanent partial disability based on loss of future earning capacity. So in order to bring that issue before the commission, you need a client, which we have, but you also need a medical opinion that explains the medical basis for the diagnosis that your client has a permanent problem and how it impairs their ability to function. So where does the expert get that? And it's not limited to just doctors, because psychologists are also allowed to do these, and so are chiropractors. They go to the American Medical Association Guidelines, 4th edition. Why? Because that's what the workers' comp law says the doctor has to do. Then they perform an examination, and after their examination, they're allowed to assign additional points of impairment, and they come up with a percentage of impairment. So what's wrong with this bill? Number one, the only way a social worker is going to get hired to do an impairment rating is if I, the lawyer, think it's a good idea. So if it's stupid or idiotic or a mistake to hire a social worker to do a rating, I'm not going to do it. Number two, there's judicial control. Commissioners, if they think that the social worker doesn't get it, can exclude the report. Number three, there was an allegation when we were over in the House that, oh, the AMA guidelines require doctors to read them. The AMA guidelines specifically says it's not limited to doctors. And more importantly, do you know who cross-examines my doctors who've rated permanency? Lawyers. They know the AMA guidelines almost better than some of the doctors. So social workers who know medicine are as equally qualified as they are to read the book and apply it. Thank you.
All right. Thank you very much. And we don't, Christine Crone, she's not here. Okay. Are there any questions for this panel? All right, thank you. Thank you very much. Unfavorable, we have Ashley Smith and Michael Daly.
Good afternoon again, Madam Chair, Madam Vice Chair. Michael Daly, on behalf of the Maryland Defense Council, very briefly. We applaud the effort to add social workers to the vocational rehabilitation process. We think it's a positive step forward. We welcome social workers to provide the skill set that they can offer to provide those types of vocational services to the injured worker. The MDC opposes the provisions regarding allowing social workers to provide permanency evaluations under the American Medical Association Guides to Permanent Impairment. Our statute specifically requires that, and with all due respect to the testimony that's provided, simply is inaccurate. The AMA guides specifically preface that the AMA guides are made for physicians, and that the evaluations of the forms that they do provide in that guide specifically says physician certified, and it has a signature line for them. All people have different skill sets based upon their training and education. It is in no way a disrespect to social workers. We just don't believe statutorily that social workers would have the training and capabilities to provide a permanency evaluation that would provide the weight needed to be considered by the commission. For those reasons, we ask for an unfavorable report. Thank you.
Thank you, Madam Chair and Vice Chair. My name is Ashley Smith for the Maryland Defense Council, and I would just say me too. Thank you.
Thank you very much.
Thank you.
And are there any questions for this panel? Seeing none, then we have one that's virtual, Nancy Egan, unfavorable.
Good afternoon, distinguished members of the Senate Finance Committee. My name is Nancy Egan. I represent the American Property Casualty Insurance Association. Our members write 89% of the workman's compensation market. And yes, thank you, Senator Klausmeier, for submitting this legislation. But we are appearing respectfully in opposition to this legislation. I will say also, me too, in our opposition to the bill. Thank you.
All right, thank you. Are there any questions for Ms. Egan? All right, seeing none, that concludes the bill hearing on Senate Bill 931. And now we're moving on to Senate Bill 431, Workers' Compensation, Occupational Disease Presumption, Long COVID, Home of the Brave Act of 2024, Senator Waldstreicher. And I have Roger Mano, Jim Lanier, Cindy Smalls, Joseph Norton and Janelle Norton. Not sure how much room we have up here, but who's all in your panel? Are these all in your panel, Senator?
That's right. We're happy to take them in whatever panels you deem fit.
Okay.
All right. Thank
Sounds
you,
good.
Madam Chair, Madam Vice Chair, members of the committee. I'm so excited about this bill. In caucus this morning, in Democratic caucus, we talked about the events of 5 days ago, and I know those of you who aren't in caucus obviously experienced it. This room was locked down, my committee was locked down, our staff was locked down. And because outside of these doors, our first responders, our heroes, were running towards danger as we were here seeking to avoid it. And that's what first responders do. They run towards danger, and they are heroes in our community. And it wasn't just 5 days ago that occurred. It happens every day. And of course, it happened a number of years ago during the COVID lockdown. Now, I get it. I don't want to talk about COVID. You guys don't want to talk about COVID. Everyone wants to move on from COVID. But there was a period of time where our first responders were facing real danger. After we locked down, but before there was a vaccine, each and every day, our first responders had to go to work and risk catching the original version of the virus, which was much more virulent and much more dangerous than the current version of the virus. They did so without complaint, and they helped members of our community. They helped them with all the regular things that happen in life, crime and heart attacks and fires. And then, of course, they helped them for those who were afflicted with COVID at that time, at a very perilous moment in our history. Of those who were essential and went to work because they were required to, a small proportion of them got COVID themselves. And an even smaller proportion of those folks now have long COVID. Long COVID is a disease recognized by the CDC. It's a multi-systemic disease. And not all of our first responders, not all of our heroes who have submitted for workers' compensation have been covered. Some have. The number who have been refused coverage, you can see it in the fiscal note, is 15. The bill before you, the Home of the Brave Act, creates a legislative presumption that if you were an essential worker during the legal term of emergency as declared by the governor, and you got COVID, and you now have long COVID, you have a rebuttable presumption that you got it at work. Why? Because it's most likely that you did. That will enable our hero first responders to receive the coverage that they need. I think at this point, you're probably saying, well, that seems like a good idea. That's good policy, but what is the cost to this? What is the fiscal note on the bill? And that's where things get a little surprising. The average claim for long COVID that has been paid is $12,000. There have been 15 claims that have been refused. And so if you just do the math, that's about a $180,000 fiscal note associated with this bill. To me, that's a price we're paying to make sure that all our first responders, all our teachers, all our correctional officers, everyone who was required to work by law during the lockdown has the coverage they need if they're diagnosed with this terrible, terrible disease of long COVID. Thank you, Madam Chair. Thank you, Madam Vice Chair. Thank you to the committee. I ask for a favorable report.
Okay, thank you. Thank you very much. Whoever wants to go next, just introduce yourself before you begin. Thank
Sure.
you.
Thank you. Good afternoon. I'm Lee Holland. I'm the president of the Fraternal Order of Police, Lodge 35 in Montgomery County. We represent 1,500 active and retired law enforcement officers. We thank Senator Wall-Striker and the co-sponsor of this bill for introducing this important legislation. COVID took a toll on our membership, just as it did with everyone else. People went to work. They, without, as Senator Wall-Striker said, without even thinking about having to go to work, but they were scared. I got people calling saying that, you know, they sleep in their garage, stay away from their families. They did all these things without missing a 911 call and being out there for the community. I started receiving calls from members that were having long COVID symptoms and filing workers' compensation claims and being denied claims, which I found to be just beyond my mind, that they had to prove that they got it at work. Well, you know, that shouldn't be someone's job. As first responders, we know we run into things, but we always know that we'll be taken care of, our bills will be taken care of, and that's not happening here. And it's costing financial burden on these few people. Sick leave being used to attend doctor's appointments, co-pays, you know, these amounts going to thousands of dollars out of first responders' pockets. So we appreciate everyone's support on this, and we ask for a favorable report with one small amendment, and that would be to extend it to September 1st, 2021. That's to cover anybody that may have gotten it during the declared emergency, which ended on the 15th of July. Thank you.
Thank you very much. Let's go next.
Good afternoon, Madam Chair, members of the Finance Committee. My name is Cindy Smalls, representing ASME. We thank the Senator for introducing this very important bill, a bill that we think is very important. We too, during the pandemic, when the state called the state of emergency, we had members who were on the front lines, from correctional officers to county workers to higher education, higher ed workers, even down to members who are working behind state hospitals, who went to work every day, not knowing the risk to themselves and their families, but did so willingly. And we believe that this bill is really crucial for them, not only to just them and their families, but crucial because it gives them the necessary benefits that they need to get better and to go back to work. So again, we thank Senator for thinking of us and introducing this bill. And with that, we ask for a favorable report on SB 431. Thank you.
The last time, James Lanier on behalf of the Maryland Association for Justice. The MAJ supports the bill because it will obviously encourage workers, especially governmental essential workers, to be able to get the benefits, especially the medical benefits that they require as a result of diseases that they were exposed to and developed and caught as a result of their job requirements. Especially when we have the governmental the government's requiring these workers to go in when someone in the private sector like myself didn't have the obligation to do so. When the government requires you to show up and you are impacted by that, you can't say no. So the exchange for that is when those mandatory requirements are done, there should be some acknowledgement that when that leads to a disease, it should make it easier for that injured worker, these essential governmental workers, to be able to file claims and get the benefits that they are entitled to. So the MAJ is also asking for a favorable report. Thank you.
Thank you.
Thank you, Madam Chair, members of the committee, Madam Vice Chair, Roger Mano on behalf of Fraternal Order of Police, Montgomery County Lodge 35. Madam Chair, it was about 23 years ago that Senator from the Eastern Shore, Senator Mouse, if I may use his name, and I worked in Congress sometime after September 11th. And Congress, dealing with a terrible situation, deaths and terrible conditions of first responders, provided a great many supports for those heroes and their families. Not enough. It was never enough, but it was an incredible program, an incredible gesture of support. This bill recognizes our first responders, our heroes, really, who answered the call when Governor Hogan issued the first disaster declaration, which took us from March 5th, 2020 to July 1st, 2021. And it wasn't just police and fire, it was park service workers, it was education workers, a range of other workers who were deemed by the governor to be essential for the continuity of government during that period. And it was because of those public service folks, those heroes, that we were able to emerge from that terrible year or two relatively on our feet. This bill recognizes the challenges that many of them faced, that Senator Waldstrecker mentioned before. There's a small number, but for those who got sick at the end of that declaration, that emergency declaration period, say in the last week, and showed symptoms sometimes later. There's a case that happened in Wuhan, China. A woman got sick 27 days after she was exposed. That takes us into July, August, and perhaps if you use 60 days, into September. So we would ask that the committee consider an amendment to extend the time in which benefits are applicable 60 days after the disaster declaration concluded. Thank you.
All right. Thank you very much. Senator Reedy, the question.
Thank you, Madam Chair. Quick question. I think, as you know, a lot of us are getting called in and out of committee, and I may be getting called here in a minute for a bill I know in another committee. So I did want to ask Senator Waldstrecker this question, because there's going to be a number of people coming up, I think, to talk about a sort of a tandem issue. This is not a commentary on the worthiness of this goal. I certainly want to look at it closely. There's also folks who are curious about people who were mandated to take the COVID vaccine, and if there were someone who was in this category of employee, and if they received some sort of vaccine injury from it, which as I've talked with folks, it'd have to be documented. Is there an openness to looking at that issue as well as we move forward?
Yeah, so I would ask that those issues be handled independently. So to the extent that there is legislation dealing with that, I would defer to this committee for an up or down vote or amendments on that bill, and same with this bill.
Okay. Do you think, so this is because these are folks who were mandated to go into work and contracted in some cases. Do we know how many people we think roughly had, I know we don't have an exact number, but do you have a rough estimate of long COVID cases?
I'll defer to my advocates.
Oh,
We
yeah.
know in the fiscal note how many people who have filed claims and how many claims were denied.
Okay.
So
It's
let
in the
me-
fiscal note.
Let me
Okay.
pull that up just so we have that on the record here. Let's see. Okay. So there have been 234 claims for COVID-19, but that's COVID, not long COVID. Then some of which also involve diagnoses for treatment for long COVID.
So probably a fraction of that, probably not even half of that would be.
That's right. And then
Okay.
earlier in the fiscal note, it indicates that 15 have made claims for long COVID that they were denied.
Okay, and
So
and actually, the rule today, we were told, was to maybe just ask one question
Okay.
to the panel, so we're gonna
Sure.
stick to it just because of the length of the day, but I know my friend Roger Mano could probably talk to me later about this issue, so thank you very much.
Thank you, Senator Reed.
All right, thank you. And Senator Mounts has a question.
Yeah, thank you, Madam Chair. And Roger, thank you for refreshing our memories of those younger years.
Yes, sir. When we had
I have a question
brown hair.
for the sponsor. So the essential workers, do you have a list of all those designated essential workers from COVID?
Sure, we're happy to provide that list. That list was created by Governor Hogan through executive orders, and it was an iterative list. It started with a more narrow group of folks and then expanded slightly larger. But we can provide that to your list. That list to you, and of course, it includes the good folks who are here today.
Yeah, I remember distinctly firefighters responding, to fire calls and things like that, where they had, picked people up and later found out that they had COVID, but they didn't know, they're volunteers. And so they really didn't know what to do. But on the flip side, I also remember there's grocery work, there's, people working in grocery stores, hardware stores, that list. And this bill would cover everyone that was deemed to be essential, correct?
Government employees.
Right. Government employees.
Yes, sir.
So if you're a non-governmental employee, you would not be covered?
That's correct.
Okay, thank you.
All right, thank you very much. Do we have any other questions? Okay, thank you.
Thank you.
Up next, so we have Joseph Norton and Janelle Norton.
Senator, I believe I signed up for this.
Yeah, James McAllister.
Okay.
Gino Wren, not sure if I'm pronouncing that right. And Jeffrey Buttle.
Mr. Buttle's not here.
Okay, all right. You can go ahead and get started. Whoever wants to go first, just introduce yourself before you speak.
No, good afternoon, Jim McAllister on behalf of the trial lawyers again for hopefully the last time today. What we're talking about here is a presumption, and I worked the 21 and 22 legislative sessions because a lot of legislators put in bills hoping to protect people who had been exposed to COVID. And what we heard at the time from the opponents was, oh, a presumption is irrebuttable. We have no way of proving it. We're done. It's strict liability. It's not. Presumption is like a tennis game. When you serve the ball, if it doesn't make it over the net, your opponent doesn't have to do anything. Well, and so what a presumption does is it says who has to serve. Do we serve? And normally in workers' comp, the claimant goes first. The claimant, it's presumed it's not work related until the claimant proves it is. Now, for certain classes of people, we say, look, the employer, either because they know more or because we like the people that we're doing and we respect their service, we reverse the roles. We say, employer, you have the burden of serving the ball, meaning you have to present evidence that is not related. And well, how do we know that? I've handled several of these cases. In fact, if you need a cure for insomnia, I submitted an article on workers' comp and COVID that I co-wrote with an infectious disease doctor as one of the exhibits today. So how do they do it? Well, they get all your clients' bank records under subpoena and find out whether they were at Disney World the week before. They look at all of, they subpoena their email, they subpoena all their records and have a way of looking through it and finding if there is a potential other exposure. But during this time period, and I wish it were so, Senator Mounts, that this covered everybody that went to work because we needed them. We ate groceries during the pandemic because there were people in grocery stores. Our prescriptions were filled because there were people out there looking at us and potentially being infected. I would love to see this cover them, but this is a great bill for great people. Thank you.
Good afternoon, Madam Chair. Thank you. I appreciate your accommodating me. Apparently, I didn't make the list. Could I ask a quick question, just to be sure that one of our members, Kenneth Jenkins, is he on the list? I hope.
I don't see Mr. Jenkins on the list.
Okay, he somehow got left off the list as well.
If we have time at that, we can maybe, why don't you just go ahead and get started?
Okay, thank you. My name is Gino Wren. I'm president of UFCW Local 1994, and I'm here on behalf of the 8,000 members that we represent across the state of Maryland. You should have my written testimony, so I'm just going to paraphrase. I think we can all agree that COVID, the pandemic, was an absolute nightmare. And I was personally involved in shutting down 5 different government agencies, including Montgomery County government. And there was so much unknown that we were kind of making up the rules as we went along. But despite all that, our heroic members, bus drivers, correctional officers, deputy sheriffs, building inspectors, and many, many more showed up each and every day and faced the unknown, not knowing if they were going to make it through the pandemic, or were they taking the virus home and contaminate their families. In my opinion, they more than deserve this representation or this benefit through this bill. SB 431 would establish a presumption. We think that's more than fair, given what they all went through. And I strongly encourage you to support this legislation. Thank you.
Mr. Norton.
My name is Joseph Norton. I was a Montgomery County police officer during the COVID pandemic. And as a police officer, I was out doing my normal job, responding to calls for service, checking businesses, talking to business owners, going to the hospital for things, going to the station, even though there were times the stations were shut down because of potential contaminations, but there were still things we needed to do there. Going to the hospital with patients, doing things, our everyday job. We did our job, no questions asked. Unfortunately, in August of 21, I came down with COVID, ended up in the hospital, ventilator, tracheotomy, feeding tube, the whole 9 yards. My wife had to plan my funeral. It was a tough time on my whole family. But because I can't sit here and say this person had COVID and that is where I got it from, there's no coverage for me. I'm still not back to work 2.5 years later, going to doctors, trying to get my health back, which I'm still at a percentage of a low percentage of what I was prior to coming down with COVID. During the time, we did everything we were told to do: wear a mask, wash hands, gloves when possible. I came home from work. I took my uniform off. I showered before going to bed, did everything we were told to do, that everybody told us to do. It wasn't enough. And I just am looking to get coverage so that I know from the future, my medical bills are taken care of, and we can hopefully recoup some of what we have lost due to missed pay, missed time at work, missed time with family, and just trying to get back to what normal was and what the new normal is going to be. So I'm looking for a favorable response for this.
Thank you, Mr. Norton. Go ahead, Ms. Norton.
Yeah.
Hi, I'm Janelle Norton, and I'm looking for a favorable report. I did plan my husband's funeral. He spent 79 days in the hospital. He does not remember getting sick. I was failed. There was no way for me to do any contact tracing in order to prove that he obtained this at work. I was informed by other officers that there were other people sick in other nearby jurisdictions, which overlap where my husband was working. And due to HIPAA, I have no access to those information to prove our workers' comp claim has been denied. We don't get an appeal until May. This has been a tremendous financial impact. Not only just currently, but in the future. My husband only had 20 years of service, which is not enough time to get it out of adequate retirement. We've exhausted our savings. We have pulled from our investments. No idea what the future looks like. Doesn't look like my husband will be able to go back to work. And what does he do as a 3-legged racehorse now? I don't know. I didn't reopen my business in order to make sure that everything we did was correct. At the time my husband got sick, people did not realize that we were just dealing with the Delta variant. I was informed in September we were dealing with Omicron, which the World Health Organization did not officially acknowledge until November 21st of 21. And what limited things that we had to do, which was 3 things, I had no problem getting statements and proving that it did not come from our interactions, and it was not enough. It was just hearsay. And I don't know what the future looks like, but I would like to know if you guys could even extend it to the end of the year, because we were still in a very severe time, even though the state of emergency ended on July 1st. This still went on into the end of the year. Thank you.
Thank you very much. Thank you very much for your testimony. Mr. Wren, who was the individual you said that was?
Kenneth Jacobs.
Okay, why don't you have him come up?
Okay.
And also Teichler is also
Wait,
here.
why
as
don't,
well.
okay, we'll get to them. Why don't you just, but stay close by, Mr. Wren, just in case there's questions. Why don't you just
no
stay up
problem.
there and we'll just bring him up real quick and then everyone else, please stay right there because there may be questions from the panel. Sorry, Mr. Norton, you can stay seated right now.
I thought there was more coming.
Yeah, there's thank you. Okay, go ahead.
Hello, Chair. My name is Kenneth Jenkins, and I'm here today to share my experience with long COVID and to voice my support for the SB 431 Long COVID Occupational Disease Workers Compensation Presumption that addresses this condition for workers like me. As someone who has experienced this debilitating effects of COVID firsthand, I believe that it is crucial to provide adequate support and protection for individuals like myself who are struggling with this illness. COVID changed my life. I came down with COVID in late March 2020. It started with a fever, body aches, headaches, and other gruesome symptoms. I took a COVID test, but back then, you don't get the results right away. It took a couple of days. When I got my diagnosis, I called my wife and broke down crying. All I could think about was all the people dying from this disease. At first, I was home, but I wasn't getting any better. Less than 2 weeks after the diagnosis, I went into the hospital and then into critical care unit. I was in critical care unit for 3 weeks under heavy sedation. My sedation medication had to be increased because I broke my restraints and removed my life support equipment twice. The first time my heart stopped and I had to be resuscitated. The second time I aspirated and got a huge hematoma on my forehead that I still have a scar from. I was finally able to breathe on my own May 4, 5 weeks after I started having symptoms. I have been recovering ever since. I had to relearn to walk. I had pulmonary rehab twice a week. My wife helps me with physical therapy at home. I have issues with swallowing because of the oxygen was in there for so long. I'm back at work, but not in the same position. I've been with Ride On in Montgomery County for 16 years. Before COVID.
Mr. Jenkins, if you could just kindly wrap it up. Are you almost done?
Yes.
Oh, okay.
Oh, I'm sorry. Before COVID, I was a transit coordinator with Ride On at the Silver Spring Depot, but can't do that job anymore. I am now the transit analyst. And while I am full-time, I am disabled from COVID. Luckily, I can telework a couple of days a week so I can continue to get some of the care that I need. I incur substantial medical expenses for ongoing
All right,
treatment.
thank you very much, Mr. Jenkins. Very appreciate it. Are there any questions for this panel? All right, seeing none. Thank you very much for your testimony. Okay, up next we have favorable with amendments. Peter DeRazio, Emily Tarsal, Derek Tischler, John Kelly, Albert Donnie.
So Peter Durant, I don't know why, that's my husband's name, so I'm Daniela Durant.
Okay, that's fine. It's like we've got room for one more chair. Brent Fuller. Okay. whoever wants to start, just introduce yourself first before you.
Passing the mic to me, huh? Good afternoon. I'm here to speak in favor of Bill SB 431. My name is Derek Teichler, and I'm a veteran police officer with 27 years with the Montgomery County Police Department in Maryland. In March of 2020, I contracted the COVID virus and was eventually admitted to the ICU. Somehow my life was spared, and upon release from the hospital, I was informed that I had brought the virus home and the rest of my family was testing positive. Contracting COVID has affected me in so many other ways we never thought possible. There's the physical impairment from the virus, but there's also the mental effect that it's taken a toll on. The physical limitations and having to come to terms with those limitations is still ongoing. The emotional and mental effects for COVID and long COVID has had on me is much harder to deal with. For somebody that used to do whatever they needed to do to take care of the house, the family, friends, whatever, is now not a possibility. As police officers or essential personnel, we did not have the luxury to work from home or isolate ourselves. We came in contact with coworkers and people in need during calls for service with no way of knowing if they had COVID or not. If we had been injured on the job in a physical way, like a fracture or anything like that, we would have been taken care of by workers' comp. We were not in this case. For others, this has been a downright devastating experience. No long-term prognosis is available from the medical establishment. Will my lungs return to normal? Will my high blood pressure resolve itself? Are all the other side effects since contracting COVID going to resolve themselves? This proposed bill will help pave the way to getting the support we need to aid in our recovery and in our future care. Thank you for allowing me to come here and testify on behalf of myself and so many others suffering from long COVID. Thank you.
Okay. Hello, Senate Finance Committee. My name is Daniela Dorazio. Please vote favorably with amendment for SB 431. Amend the bill to include compensation for those eligible employees who were injured by their COVID-19 vaccination. My husband got long COVID and severely struggled to work to provide for our family as a breadwinner. My son and I were terrified that he could die. Then his job threatened him with loss of job if not COVID vaccinated, despite having the virus prior. He got the J&J COVID-19 vaccine and got very sick with a powerful headache, ptosis, fever, whole body pain, and a symptoms like a stroke. Again, my son and I were terrified that he could die. Only a few months before, 2 Maryland friends, 50 years old, died shortly after vaccination, so my heart stopped because of fear that my husband could die, just as our friends die or become paralyzed and unable to work to provide for us and have a healthy life. We as a family went through serious mental trauma from losing young friends shortly after vaccination, from government tyrannical overreach over our bodily autonomy and freedoms, and suffered psychical trauma from COVID-19 virus and vaccine. I'm here today to speak up for Marylanders who are vaccine injured and on behalf of those emotionally hurt by COVID restrictions. Please add those eligible employees who were COVID vaccinated and became seriously ill to the list of the heroes who should be getting financial support. Thank you.
Whoever wants to go next, just go ahead.
Thank you. My name is Albert Donnet. I'm a consulting toxicologist and environmental health engineer based in Hyattsville. I'm speaking for myself, not any of my clients. I am also vaccine injured from a Moderna shot. After the first shot, I had no reaction, but after the second, I became quite ill and still have a pain in my arm from that experience. My wife was injured from her first, not her second, and fortunately recovered. In that experience as a toxicologist, I was able to study what happened to my wife's carbon monoxide level This is not carbon monoxide she inhaled, but that she made. And when she got the COVID vaccine, her carbon monoxide level went up 19-fold overnight from 1 part per million to 19. The next morning, she had a fever of 101, flu-like symptoms, and couldn't get out of bed. And the next day it was 24. So that tells us there's a large increase in CO stress response from the vaccine. When she got COVID, it only went up to 6 ppm in contrast. I'd like to finish by talking about a study published in December 2022, a large study of over 280,000 Americans, which showed that there was a very similar pattern of illness that was more prevalent after vaccination compared to before. The same series of illnesses seen in people with long COVID. The study was able to show that they had the same patterns of illness, but there were a few subtle differences. And I say for those who want to know how might we distinguish them, both groups had a higher than expected prevalence of a disease called POTS. And the COVID vaccine injured had a much higher prevalence of myocarditis, a heart condition, as while the long COVID group, instead, their most common new complaint was diabetes, and yet they both had POTS. I urge you, if you find it compassionate and you find the budget to support those injured on the job by the long COVID, please also find it to support those injured by a mandated vaccination. Thank you.
Good afternoon. My name is Emily Tarcell. I'm a licensed therapist and president of Health Choice Maryland. We favor SB 431 with an amendment to compensate those employees who are also COVID vaccine injured. All medical procedures and products come with risks such as that from the COVID-19 vaccine. There are now documented studies about serious outcomes like blood clots, heart inflammation, seizures, autoimmune disorders, chronic fatigue, POTS, etc. COVID vaccines were fast-tracked approved, and pharma and medical providers were given immunity from liability. So where do heroes who were COVID vaccine injured and there to help other people, where do they go in their hour of need? Heroes like those testifying suffer serious afflictions, but were abandoned by the system, a system which in which they lost their voice, in which they were censored or silenced. There were no marathons or ribbon races for them, where there's no research for you and your case is considered rare, and your catastrophic harm is being discounted, where you have no legal recourse and you're mandated, where you were mandated to accept 100% of the risk, while the government and the manufacturers were protected with, and they have no obligation to help you, and where you have little to no chance for any compensation because the COVID vaccine compensation program, the CICP, is broken and underfunded. And these heroes were abandoned by the system, left to fend for themselves medically, financially. We ask that they be added to this bill for compensation. And I would also suggest that the criteria for determining COVID vaccine compensation could be similar to that used in the National Vaccine Compensation Program. I'm happy to send that information to you or tell you what those criteria are. But please include these back in your, we recommend an amendment to the bill. Thank you.
That was amazing. See, that was amazing timing, right on 2 minutes. I'm one of those people. So my name is Brent Fuller, father of 2, husband, supporting my family, also supporting the DoD and intel agencies. I was subject to the executive mandate to get the vaccines, right? I waited till the last minute I could, and I took the Johnson & Johnson shot, right? Injured by it. I have my documentation from Johnson & Johnson. They agreed that my symptoms come from this shot, right? There's a myriad of them. I only have one lingering one, that's tinnitus. And I have medical bills for this the rest of my life. I'll spend thousands, I'll spend tens of thousands of more throughout my life dealing with this issue that causes a lot of people to commit suicide, right? I'm not at risk of that, but there are lots of people who do it, and it made me appreciate for the first time in my life how detrimental something like tinnitus can be. Imagine sitting in this room every minute with that smoke alarm sign going off in your head. You can't turn it off. The only thing that stops it for me is these treatments that I have to get. In my case, I sort of slipped through the cracks, right? I'm a contractor, but I worked for the government. We kept going. Terrorists don't stop, right? I kept doing my work through this whole time. I went to the government, tried every single avenue I could. I'm not a government employee directly. I can't go to OIG offices. I don't have any of these compensation programs. I had no option to not take the vaccine. I looked at religious exemption. That was not available to me because it would be lying because I didn't have a religious exemption. I could not use science or any other thing I could to not get this shot. I'm suffering from all these consequences. I would love for there to be some recourse in Maryland. There, right now, workers' comp has a timeout. I can't even file anything. There's no recourse for me at all right now. I would urge that you all increase some ability for people who went and took the shot, did what they were commanded to do. Again, list of known, these are known, there's no question, right? I got the shot. I got the afflictions from this that are documented by a drug that was never even approved by the FDA, right? To be clear, Johnson & Johnson shot for the one I had, not approved, EUA, taken off the shelf, millions of doses destroyed because of safety hazard. And right now I have there's nothing I can do. Like, please offer me a path out and many other people like me that are afraid to come forward for fear of consequence from their employers.
Very much.
Good afternoon. My name is John Kelly. I support Senate Bill 431 with amendment that persons injured by COVID-19 vaccines be included. In 2021, the New England Journal of Medicine published an article that recognized the potential risk of COVID vaccines and the need for adequate compensation for those injured. It said, all potential vaccine recipients face a dilemma. Should they risk becoming infected or risk having vaccine injury without sufficient access to compensation? FDA Director Peter Marks recently said the program that tracks COVID vaccine adverse reactions had an avalanche of reports shortly after the vaccines were rolled out. There were more reports for COVID vaccines than for all other vaccines since the reporting system began in 1990. Because of underreporting, the official numbers could be 30 times greater. As for compensations, those injured by COVID vaccination cannot sue pharmaceutical companies. They must file claims with the federal agency that countermeasures injury compensation program. Their chances of success there are slim and the amount of compensation small. Almost 13,000 claims were filed as of January this year, but only 11, less than 1 in 1,000, only 11, 1 in 1,000 have been paid, and the payment has been a paltry $3,700. The program has a backlog of 11,000 cases. At the current rate claims are processed, it will take 10 years to complete them. It is clear that those injured by COVID vaccines have neither sufficient access to compensation nor adequate compensation when it is paid. There are people who did what they were advised and urged to do by public agencies, and in many cases mandated to do by public agencies or lose their jobs. They have been abandoned by public agencies they trusted.
Mr. Kelly, can you wrap it up, please?
Yes.
Thank you.
Please include the vaccine injured in this bill, including them would help correct this failure and restore trust. Thank you.
Thank you very much. I think everyone has an opportunity to speak. Senator Ellis has a question.
Yeah, thank you, Madam Chair. Thank you for your testimony. I have a question for the bill sponsor. Senator, do you accept these amendments as friendly amendments, or do they enhance the bill, or what's your view on this?
Thank you for clarifying. So this has been an interesting experience and perhaps my first experience. And I'm deeply empathetic with the vaccine injuries that have been expressed here. The first panel was here on behalf of the bill, and some other folks with a separate issue who perhaps would be better situated with a separate bill have decided to testify to the amendment that they are seeking. That is not my amendment. It's not a friendly amendment. I appreciate the issue that they have raised, but this bill is intended for our first responders, our police officers, firefighters, EMS workers, and other essential workers for a very specific COVID-19, long COVID disease.
Okay,
So
great.
Thank you for that clarity.
Thank you, Madam Chair.
Thank you, Senator. Any other questions? Okay. Thank you very much, this panel, for your testimony. We have two other favorable with amendments. Esther Szabo, apologize if I'm mispronouncing it, and Jill Capper. You can go ahead and get started. Just introduce yourself.
Yes, hi, good afternoon. My name is Jill Capper and I'm here to support SB 431 with an amendment to include workers who are COVID vaccine injured. Workers like my friend Charlie Bell, who submitted written testimony but is too sick to appear. Charlie is a 54-year-old U.S. Navy veteran who worked in a Navy shipyard. He was vaccinated with the required COVID shots in April 2021. Soon afterward, he began experiencing excruciating back and neck pain and a hardened stomach. His legs had internal vibrations and pins and needle sensations. He couldn't lift his legs to walk and had shooting pains down his arms. This all started after the second COVID shot. He went to the ER and was referred to a doctor who did a lot of tests. The test showed inflammation in his neck and lower back, but it took 2 years before he found a doctor who seemed to understand what was happening to him. He was diagnosed with an autoimmune disorder of the muscles and connective tissue. He asked the doctor if the vaccine caused his condition or if it was from long COVID. The doctor confirmed that he was vaccine injured. He said that the testing showed that his body was still making very high level of antibodies, and this was causing an autoimmune reaction. The doctor said that doesn't happen with long COVID. Charlie felt gaslighted by the doctor who failed to report the inflammation detected after the shots and who didn't provide early treatment to calm his immune system. He is now disabled and barely survives on disability and Medicaid. He couldn't apply to the CICP program because the year to apply had passed. It has been a disaster for Charlie. The government forced him to get the shots, and now they ignored the vaccine injured. Charlie said that he wouldn't even be alive except for the compassion of his doctor, who is paying for his prescriptions and doctor visits. Please don't abandon the COVID vaccine injured and amend the bill to include them. That's it. Thank you.
Hi, my name is Esther Sabo. I'm a citizen, resident in Maryland. I have 2 children who were mandated the COVID-19 vaccines. Luckily, they seem to be fine. However, tens of thousands are not. So I am also in support this bill with the amendment. The COVID-19 vaccine was developed in a couple of months, which is a short period compared with the usual 5 to 10 year long process of vaccine development. These vaccines went through a minimal clinical trial process, and their manufacturing process development was also warp speed. It is thus not surprising that today there are tens of thousands, possibly millions of people who are experiencing serious COVID-19 vaccine injuries as a result. I also do know that since this was mandated for the University System of Maryland, some employees of the University System of Maryland they have been under so much coercion to get this vaccine. And even though they are vaccine injured, they don't dare to show up here to testify because they're still in fear of losing their job. So I would like to advocate for them. I will also show some data, and it's in my testimony too, from the so-called the Global COVID Vaccine Safety Project, GCOVS, which aims, among other issues, at the following activities: conduct association studies for events that have been identified as likely associated with COVID-19 vaccines, which are myocarditis and pericarditis and mRNA vaccines, thrombosis with thrombocytopenia syndrome, vaccine-induced immune thrombotic thrombocytopenia, TTS, VITT, and viral vector vaccines, Guillain-Barré syndrome, and viral vector vaccines. These are the increased risk that can happen. Myocarditis after Moderna first dose, which are 3.48 times higher. Myocarditis Moderna second dose, 6.1 times higher. Pericarditis after AstraZeneca third dose, 6.9 times higher. Please do not leave out the vaccine injured from this bill. Thank you.
Thank you very much, Senator Mounts.
Thank you, Madam Chair, and I appreciate your testimony and testimony of the prior panels. I just had a question for you. When you talk about being injured from the COVID vaccine, do you feel there's a stereotype placed on you to say anything bad about the vaccine and what the symptoms or the experiences that you've had?
Of course. Yes, go ahead.
Yes, certainly. As I said, actually last year, during working on a bill, we have brought someone from the University System of Maryland, an employee, to testify in Zoom meetings. And she had written up her testimony, but today she doesn't dare to come here because she is fearing for losing her job.
Have you experienced situations where people didn't want to hear about injuries from the COVID vaccine?
Oh, certainly. I mean, that's going on in many, many communities. So these people who were coerced getting the vaccine and they got it because they wanted to keep their jobs, they're not allowed to talk up now that they have a symptom. And also, I think that the group who testified in favor of the long COVID, which is a wonderful bill, I wonder if they got a COVID vaccine, how can we differentiate between COVID vaccine injury and long COVID vaccine?
Sure, but important to get on the record. I don't want to go into too many, but you do realize this bill only applies to government employees.
Yes, certainly, but it's a good start.
Right, but thank you for sharing that personal information.
All right, thank you. Any other questions? Okay, thank you very much for your time. Now we have the unfavorables, Carmine D'Alessandro, Julie Murray, Michael Daly, Angelica Bailey Thupari, and Brianna January.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Carmine D'Alessandro for Chesapeake Employers Insurance Company and the Injured Workers Insurance Fund. Happily to be opposing the last compensation bill of today, SB 431. Couple points. Obviously, there's a retroactivity provision in this bill. I've spoken about insurance rates already in some of the other bills. Obviously, insurance rates have been set for that year, and employers have paid their premiums. So it would be arbitrary and non-responsive to now go back in time to assess rates 2 years in the past. Senator Walstriker discussed the fiscal note, and I'm fairly certain that the fiscal note just discusses data from Chesapeake and IWIF. I know there was a lot of testimony from individuals working in Montgomery County. Obviously, I'm not discounting that. I'm just the riveting testimony. My data does not reflect that county. We don't insure that county. So since 2020, those 15 denials that Senator Waldstreicher indicated, that's for all COVID claims, not just long COVID. So Chesapeake and IWIF have only had 15 claims denied since the onset of COVID. Many have been accepted. It's my understanding that we've had 15 to 18 COVID presumption bills over the years. And I believe the commission's data supports Chesapeake's data that many of these cases, most of these cases are accepted. The state of Maryland did a fantastic job in contact tracing. So we denied what became known as patient zero. If you went to a wedding and contracted COVID, we denied your claim. If you brought that COVID into the workplace, we accepted the claims of everyone at work you have infected. So we have had not the experience that was testified to. The last thing is a procedure, and we don't distinguish between long COVID and COVID. Once we've accepted your COVID claim, it's a COVID claim. We don't make a distinction. And lastly, and this has come up in other COVID presumption bills, COVID is an accidental injury, not an occupational disease. In the Workers' Compensation Act, presumptions only attach to diseases, not accidental injuries. With that, thank you, Madam Chair, Madam Vice Chair, members of the committee. Respectfully opposing the bill. Thank you.
Good afternoon, Michael Daly on behalf of the Maryland Defense Council. We join in Mr. D'Alessandro asking for an unfavorable report for the reasons he has already stated. The Maryland Defense Council's primary concern looking at this is, as Mr. D'Alessandro indicated, the fact that it's deemed an occupational disease when the commission, in the few cases that the data shows were actually litigated on the compensability issue, were deemed accidental injuries, not occupational disease. So on its face, this bill would not reflect the application of the law to these types of cases. Moreover, overwhelmingly, the data establishes that employers, insurers across the state, not just government entities, did a very admirable job of accepting cases, making sure their employees were provided all of the resources that were humanly possible during that time. We do not believe that this bill accurately reflects the reality of the majority of the Maryland workers who unfortunately were exposed to COVID and diagnosed with COVID in the course of their employment. And finally, the retroactivity is of great concern. Our Supreme Court has certainly dealt with that issue in other scenarios, and we submitted written testimony on that fact. But the fact that this is asked to be, applied retroactively, we did not believe would withstand a Supreme Court analysis. For those reasons, we're asked for an unfavorable. Thank you very much.
Good afternoon again for the last time. Julie Murray on behalf of the Maryland Defense Council. Just to point out two other issues that MDC takes with this bill, and expanding a little bit. We have dealt with COVID presumption bills since 2020, the 2021 session. And in large part, when we dealt with those, we dealt with a lot of data. And this committee in particular heard data from the commission, and it was largely determined that COVID claims were appropriately being handled during that period of time by the commission. They were hearing all of the evidence. They were determining which cases were compensable based on the facts of those cases, and they were making findings. The tying in the retroactivity to that issue is the fact that this bill would apply to claims that essentially could have already, and in some cases, it sounds like from the testimony of the proponents, have actually already been litigated by the commission. In adopting this bill, you're taking our statute of limitations, which is 2 years under the Workers' Compensation Act, and extending it by permitting people to go back now and litigate long-haul COVID cases that occurred from 2020 until some period in 2021. We believe that that is a very large problem. It impacts our members significantly in that most of those claims have already been adjusted and handled. Most of those, the circumstances, the investigation into those claims, that period of time is long gone. For those reasons, as well as the other reasons that the panel is going to discuss, we would respectfully ask for an unfavorable report. Thank you.
Good evening, Committee. Brianna January with MACO in respectful opposition to SB 431. Counties appreciate the goals of the bill. However, we do have significant concerns, especially around the creation of a presumption. Committee, when you create a presumption, the courts essentially take that as meaning that no matter other circumstances that may have led to a diagnosis, that diagnosis is legally attributable to the job. Counties are especially leery of creating a presumption around long COVID, which is a diagnosis that currently does not have medical consensus. And in practice, Committee, it would be nearly impossible to prove whether or not someone's diagnosis was the result of catching COVID at work years ago, or from any number of other sources and exposures. Despite that, under the bill, it would mean that counties would basically be on the hook for lots of long COVID claims, even if exposure did not actually occur on the job. With those considerations, MACO does urge an unfavorable report. Thank you.
Good afternoon, Angelica Bailey Thupari for the Maryland Municipal League in very respectful opposition. And I will just say me too. Thank you.
Great. Thank you very much. Any questions for this panel? Oh, and our chair is back. All right. Thank you very much. We're next going to go to the virtual favorable, all of which are favorable with amendments. Our first is Sean Barkovich. If I'm pronouncing that correctly, you can go ahead.
Hi, good afternoon. My name is Sean Barkovich. I'm a 54-year-old research nurse practitioner. At the peak of my career and with no prior medical issues, I received my first Pfizer COVID vaccine in December of 2020. Within hours of that, I experienced paresthesias along my right injected arm, which spread into my face. Against medical reason, but given mandates and pressure, a neurologist recommended I proceed with the second dose. Within 4 days of that dose, the paresthesias returned with intensity, accompanied by a severe ringing in my right ear to a suicidal level. In the following weeks, I encountered a myriad of debilitating symptoms, including cardiac arrhythmias, which led to a cardiac ablation, fluctuating blood pressures, stinging, burning, stabbing neuropathies, muscle twitches, and nervous system dysfunction. Frequent testing showed no presence of viral COVID, and the temporal association of my symptoms with the vaccine was crystal clear. It's well documented in my medical records and a published study. Desperately seeking care as a nurse and an advocate, I assumed there were robust systems in place to protect those harmed. Quickly, I learned there is no help and that our current adverse events reporting system is politicized and the compensation system is utterly broken. They protect the industry and not the patient. Adding to my disbelief was censoring my efforts to advocate for help online and being labeled misinformation. I am pro-science. I took the vaccine. Denying such reactions is the real anti-science. Deliberately failing to help those harmed is a crime against humanity. And the lack of transparency is a driver of vaccine hesitancy. During the height of the pandemic, I was the nurse hero engaged in COVID interventions, including, ironically, vaccine research. Now I live a life with cruel symptoms, with lost income, mounting medical bills, a medical career in ruins, and denied disability. I'm often minimized as rare. Well, I'm here to testify today what rare really looks like. Please don't render us a hidden and acceptable human casualty. Please amend the bill to include those harmed by the COVID vaccine. Thank you.
Thank you for your testimony. Is this Mr. Andre Cherry? Please unmute, Mr. Cherry, we can't hear you.
Hello?
We have you now. Thank you.
Good afternoon, Madam Chair and honored members of the Senate Finance Committee. My name is Andre Cherry. I'm 24 years of age. And for almost 3 years, I've been completely disabled by the COVID-19 vaccine. Since my second Moderna injection in June of 2021, I have not been able to get a job, finish my education, or travel independently. I'm a prisoner in my own body. I spend my days in this hospital bed my family has bought for me or in my wheelchair. My condition and various symptoms, which are listed in my written submission, confine me to my home and require many resources as well as constant care and supervision to ensure my safety. I and the millions of other COVID vaccine injured across the country have spent years searching for acknowledgement, diagnosis, and treatment at great personal expense. Our injuries and the deaths of our loved ones caused by the mRNA shots have left us abandoned, ostracized, and reliant on the kindness and empathy of those who share our plight to endure our suffering. Last year, I testified before the Health and Government Operations Committee in favor of the amended Vaccination by Choice Act to protect students and government employees from the COVID vaccine mandates, and warned that forcing the citizens you represent to choose between their health or their education and career was harmful and unjust. That bill, as far as I know, has never passed into law. Now we come to the issue of compensating not only those who endure long COVID, but victims of that unjust choice. The federal safety nets available for the COVID vaccine injured or bereaved are woefully inadequate, as you'll find in my written submission. Hardworking Americans who face the debilitating consequences of complying with the mandate the government implemented deserve adequate compensation and recognition for their unimaginable suffering. Therefore, I come before you as a concerned citizen in favor of the Home of the Brave Act as amended by Senator Reddy, and ask that the state of Maryland will do for her citizens what legislators in DC will not. Thank you.
Thank you for your testimony, Mr. Cherry. Next, we have Danielle Baker.
My name is Danielle Baker. I'm a registered nurse. I'm 44 and I'm testifying today to hopefully help you understand why it is important to vote this bill favorable with amendment. I'd worked for the same hospice for 17 years during the COVID pandemic. In 2020, I contracted COVID, and after that, I had symptoms yet to be named, but ended up being long COVID. I did not know I had long COVID until 2021 after taking after having a vaccine reaction. When I took the COVID vaccination due to workplace recommendations and eventually mandates, I had not wanted to take the COVID vaccination and had not fully yet been studied, but we did not know the devastating side effects, adverse events it could have. As stated above, due to workplace expectations, I did move forward with vaccination, and after the second dose of my only series, I became ill over the next few weeks, lost my ability to essentially walk, take care of myself, and control my bodily functions, just to name a few. 3 weeks after my second dose, extensive testing and procedures, I was diagnosed with transverse myelitis. Essentially, my immune system was low because of long COVID, and my body attacked my spinal cord, rendering me disabled for life. Due to how the compensation systems are set up, I have not been able to secure financial compensation for my injury that were a direct result of working as a nurse in the COVID environment, as well as taking a vaccination for the benefit of my employer. For that very reason, I've had to take my former employer all the way through the court system, and I have now in civil court awarded a jury trial in order to gain access to financial support for my workplace injury. So for that reason, I am asking for favorable with amendment. This is a devastating nightmare that nobody should have to endure.
Danielle, I'm so sorry to hear about your illness. Do you have any questions for Danielle from the committee? Thank you for testifying with us.
Thank you. It's also attacked my heart and my lungs and most likely limited my life when I was 44 and healthy before.
I'm very sorry, but thank you for sharing that with us.
Thank you.
Marjorie?
My heart goes out to all the injured. Article 25 of the Universal Declaration of Human Rights notes that everyone has the right to security in the event of disability, and my testimony is in the form of a song. Well, I got my vaccination and then suddenly, behold, a facial paresthesia, and I went home and told myself to not freak out, do some work, got some work done, yeah, I'm strong, but then the fever came, oh no. Whoa. Well, I tried some meditation, opened up my sleeping app, but my temperature was rising. Every day since then, I've really felt like crap. Neurologists and legislators, many do not care. They just say misinformation, not causation, or what happened to you is quite rare. I tell folks of the whistleblowers, people harmed in trials, unreported, unsupported. I cite the facts and impacts. They won't read the files. Their eyes are closed. They cannot see the suffering. They will not lend an ear. It's safe and it's effective. Boost or you're not welcome here. The workers' compensation law is just right for this case. Compassionate support will bring us to a better place. The injured in America have zero right to sue. Compensation for the injured, well, it depends on you. La, la, la. That's your right.
Thank you for your presentation. Do I have any questions for this witness? Have a good evening. Thank you. That ends the hearing. And it also, well, it ends that hearing for that bill and it ends the hearing for the afternoon. We are going to take a few minutes so Tammy can switch us over to our voting session. Thank you all. I hope you didn't mind being limited today, but it helped us get through 140 witnesses, so I appreciate it.